Okay, good morning. It being 10 o'clock, I'm opening the public hearing on Senate Bill 228, and I call the prime sponsor, Senator Bradley.
Good morning, Madam Chair. Good morning, members of the committee. Thank you. For the record, Jeb Bradley from Wolfboro. I'm pleased to be here to be able to introduce Senate Bill 228, which was a bill that passed on a voice vote in the Senate and had near unanimous support at the public hearing. I was asked to introduce this bill by the Society of Physician Assistants. I think it's going to increase access to health care, especially in areas of the state that I represent, more rural areas. It will help contain costs, and it will make sure that New Hampshire is an attractive state for physician assistants to practice, especially given that Maine and Vermont have enacted similar legislation. We use Vermont's legislation almost as a model for this, but when I was asked to introduce this bill, I made it very clear to the head of the physician's assistants that they had to work with the medical society and the hospital association, as well as OPLC, to come to terms on an agreed upon bill. Dave Cuzzy is going to be here. He is here representing the physician's assistants, and interestingly, he told me that there's not a single physician assistant able to testify today because they all are overwhelmed at work. So if ever there was an indication that this bill is necessary, I think that's it. A couple of things on the bill I think that are important to note: that it does not remove what's known as the legal tether, or the relationship between a physician and a physician's assistant, and it does not allow a physician assistant to practice independently. That obviously was very important to the medical society and the hospital association. It does not absolve a physician from liability if they have involvement in the care of a patient. The bill makes this clear. What it will do is align current physician assistant regulations to better reflect how they actually practice medicine in today's modern healthcare world. So the bill has five components. Number one, it takes the existing legal requirement that a physician and a physician assistant sign what's known as a supervisory agreement. That has to be on file with the Board of Medicine, and it combines it with the requirement that a healthcare employer has a practice agreement in place. Two, that practice agreement outlines how the physician assistant interacts and collaborates with physicians and any other member of that healthcare team. The bill calls this a collaboration agreement. Then the bill will make clear that physician assistants are liable for the care they provide, that physicians aren't liable for care provided solely by a physician assistant simply because they've signed a collaboration agreement. But again, the amendment that the Senate adopted makes it clear that this bill does not indemnify physicians if a physician is part of the care of that patient. The third thing is the bill allows a physician assistant to directly bill the public and private insurers for care they provide and receive direct payment from those insurers. The bill makes it clear this would only be allowed when permitted by federal law and only when appropriate based on the physician assistant's employer setting. Fourth, the bill stipulates that the physician assistant does not need a collaboration agreement to provide care during an emergency or a disaster, which we've seen come into play with COVID, but also other situations in the recent past. And fifth, the bill makes it clear physician assistants do not need a collaboration agreement to volunteer to provide basic medical care at summer camps, charity road races, and similar activities. And lastly, I just want to touch base very quickly on the one person that testified in opposition to the bill, an attorney representing the Association for Justice, that requested that liability coverage be required in the bill. And if you look on page 6, starting at line 22, it says that physician's assistants shall have adequate, valid professional liability coverage. So happy to try to answer any questions. Mr. Cuzzy, who was involved in all of the discussions and collaboration on this bill, is also here.
Okay, thank you very much, Senator. Are there any questions? Representative Sytek.
Thank you, Senator Bradley. Would you mind going over the liability provision again? It sounded, I had trouble understanding who's on first.
Okay, so if you look on page 6 of the bill, 328D18, I'll just read it. I think it's pretty clear. Physician assistants actively engaged in providing medical care shall have adequate, current, and valid professional liability insurance coverage. So it requires them to have coverage.
I guess I'm talking about when is the physician absolved from liability and,
Page 5, line.
oh, that's, all right, so.
Okay.
Other questions? Representative Pearson.
Thank you, Madam Chair. Thank you, Senator Bradley. The professional liability insurance coverage that you're referring to, would that in layman's terms be just simply malpractice, or is that a different type of insurance coverage?
I think it's meant to include medical malpractice and that
Okay.
kind of coverage, yes.
Great, thank you.
Other questions? All right, seeing none, thank you very much, Senator.
Thank you very much, Madam Chair and members of the committee. Have a good week.
David Cuzzy.
Good morning. Thank you, Madam Chair, members of the committee. For the record, my name is David Cuzzy with Prospect Hill Strategies here in town, and I'm here this morning on behalf of the New Hampshire Society of Physician Assistants. As Senator Bradley mentioned, again, due to the shortages and the, now the demand on healthcare, now that the pandemic is easing, hopefully permanently, unfortunately, no members of the board, all volunteer board of the physician assistants, and I'll refer to the Society of Physician Assistants as NISPA, if you will, throughout the testimony, NHSPA. So I'm here on behalf of NISPA's president, Steve Alexakos, and the 1,000 PAs in New Hampshire, as well as the dozens of PA students who are enrolled in the Masters of PA programs at Franklin Pierce University and at the Mass College of Pharmacy and Health Sciences in Manchester. As you might expect, we do support SB 228 as passed by the Senate. And I just thought I'd take a second, just for those who may not be as familiar on this committee with PAs. There's some misconceptions that have been kind of baked in, if you will, over the many decades since the profession was introduced to the healthcare field many decades ago. But PAs, despite the name, PAs are not assistants to physicians. They are, in New Hampshire, they are licensed medical providers, and this is the case nationwide, who diagnose illness, develop and manage treatment plans, prescribe medication, and often serve as a patient's principal healthcare professional. They receive, they do receive a master's, and they receive thousands of hours of training before they are considered physician assistants and able to practice medicine. And this is the case in every state. They provide care in every medical setting and every specialty, and they do improve access to health care across the state and across the country, especially in rural areas. As I mentioned, they work in hospitals, medical offices, urgent cares, community health centers, nursing homes, and other and workplace clinics throughout the state. And they also, of course, work in federal government agencies and at the VA medical centers, including in Manchester. So Senator Bradley did a great job introducing the bill. I'll just touch on a few more details, and Representative Sitek, maybe I'll give a little more detail on the liability provision as well, if I may. So I think it is important to note what this bill does not do. First of all, I know it's a 6 or so page bill, but this bill is not in any way a major overhaul of PA practice regulation. There is no change in the regulatory regimen for PAs at all. There are no real major reforms of any kind that this bill proposes for PAs. There's no expansion or change of the scope of practice for PAs. I would respectfully suggest to the committee that this really provides, as Senator Bradley outlined, 5 common sense changes to represent how PAs now practice in a modern healthcare setting that really need to be updated since the PA statute was created and amended over the last many decades. As Senator Bradley mentioned, this does not provide a path to independent practice for PAs, period. I know there's been 1 or 2 folks who maybe have suggested that, but that is not accurate, and that is something that was important to the medical society. Mr. Padmore is here, can validate that. 21 states over the last 5 years have introduced PA practice or passed and adopted PA practice modernization legislation, most notably Vermont and Maine. Massachusetts has a bill pending. New York State also has passed a bill, and so has Rhode Island. And as Senator Bradley mentioned, a good portion of this bill before you was taken from Vermont. And again, the goal here is to make sure that we are attracting and retaining PAs, that our regulations are in line with other states and are updated so that there are no barriers to PA employment here in the state, and that people are seen in the right place, in the right location, by the right provider. I would like to thank the Medical Society and others for their collaboration on the bill. Senator Bradley mentioned a lot of them. Other supporters include Convenient MD, Amoskeag Health, which is the community health center in Manchester, North Country Health, Derry Medical Center Primary Care, and the Nurse Practitioners Association. They've all indicated their support, and I'd like to thank the Hospital Association, the Board of Medicine, and OPLC as well for their collaboration. So Senator Bradley mentioned how this bill would create a collaboration agreement. All that is, very simply, is you have the responsible supervisory physician form right now in current law that must be sent to the Board of Medicine and kept on file there. Also, per regs, you have a practice agreement that must be kept on file at a PA's employer that really just outlines how a PA interacts with members of the healthcare team. If it's a physician, if it's a respiratory therapist, other folks. And all the bill is doing is it's taking that RSP and that practice agreement, combining them together in one document and calling it a collaboration agreement. So there's still that need to name a physician and a PA with a signature from both, and there's still a need for a practice agreement. We're just combining it, and that agreement will be maintained on file at the place of employment, as the practice agreement is now. So none of that changes. There's still that legal tether, and there's still a legal, and there will be in statute now a requirement that a collaboration agreement is kept on file. The collaboration agreement could say whatever the employer and the PA wants, but what the bill does is it says it must identify at least who the collaborators are, how the PA communicates with members of the healthcare team, and when, based on their education, training, and experience. So again, not a big reform, just I would respectfully suggest a streamlining of the regulatory process there. In terms of, and this, Representative Sitek, this may help address your question. In terms of the liability requirement. So right now, PAs can be sued for the care they provide, but right now, the physician who signs what is that RSP form, they can be sued right now just for the simple fact that they had their name on that form. They may not have had anything to do with that patient interaction. They may have been seeing their own patients through that whole time, but they can be sued simply because they're on that piece of paper. All the bill does is says that no longer can be the case. You no longer could sue that physician simply because they have signed what this bill would call the collaboration agreement. But it makes very clear that that physician, if they are involved in any way, shape, or form, they are still liable. They can be sued if they were involved in that patient interaction in any way, shape, or form. Even if it's just the PA picking up the phone and asking a question, now the liability, of course, would kick in. That's how it is now, of course, but the statute makes that clear. So we think that's an improvement. The liability issue has always been a barrier to employment for PAs because no other healthcare provider has that requirement put upon them, of course, that they have a legal tether to a physician. And so a lot of times healthcare employers or physicians employed by healthcare employers, they don't like to be on the hook to be sued by signing these RSPs. So by removing that makes PAs perhaps a little bit more attractive when compared to other healthcare employers when they're looking to change jobs. The issue of direct billing, again, PAs they're the only healthcare providers that cannot right now bill directly or be reimbursed directly from health insurers, be it public or private insurers. This is really kind of a niche issue, but it really impacts those who provide care in more rural settings. This allows them to be able, a lot of these more rural healthcare providers maybe don't have the administrative or don't want to bear the administrative costs. So for the PAs to be able to bill directly and take on that administrative burden on their own is really what this is all about in rural healthcare settings. In big employment healthcare settings, if it's Dartmouth Hitchcock, others, this does not apply and does not require any healthcare provider to have a PA bill directly or be reimbursed. It allows that flexibility based on employment setting. Senator Bradley mentioned that this bill makes clear that a PA would not need a collaboration agreement for providing emergency care. I think this is the Good Samaritan situation. Car accident on the side of the road. Of course, they may not be able to be physically, of course, there wouldn't be their collaborating physician would not be present, and they may not be able to reach them electronically when they're rendering care. That really gets to that issue. And then with the volunteer care at charity races or things like that, this is just allowing PAs to provide, basic general care. Of course, if someone had a more serious injury, there'd be a transportation to a hospital or something along those lines. They can volunteer at their child's summer camp, that type of thing, and they don't need a collaboration agreement for that. So I would respectfully suggest that these are 5 common sense changes to existing law. Again, no big overhauls here, and again, we appreciate the fact that all stakeholders were able to come together to agree on a bill, and I look forward to answering any questions from the committee. Thank you, Madam Chair.
Thank you. Representative Fellows has a question, and then Lucas.
Thank you for taking my question. Do physicians assistants have specialty training before they enter into these agreements? Because, the ones that I've encountered have all been under a specialty doctor, like an ENT or something like that. So do they have that training before they start? Or do they enter these agreements with just a general background in medicine?
So when they, and this could apply to a PA right out of school, or this could apply to a PA who is 20 years into their career. So the answer is they must sign that practice agreement, and they must have that signature agreement with the doctor. Right now, it's the RSP. We'd look to call it a collaboration agreement when they start their employment. The practice agreement makes clear, though, that they can't do anything within that specialty that is outside of their education, training, and experience. And so if someone is changing specialties, for example, I think would be or either new to a specialty, regardless of the scenario. They're right out of school, or they're coming from maybe an ENT and going over to urology. In the law now would say that they cannot be doing anything. They could not be doing anything in terms of providing care that would be outside of their training, education, and experience. So there may be additional training that they would need to undergo, perhaps even before they start in that specialty. But there certainly would be experience that the physicians would require before they're allowed to be off doing anything on their own. If you're talking about perhaps a surgical setting or something like that, a PA is not performing surgery or anything along those lines.
So let's just take the ENT, for
Sure.
example. So this physician assistant graduates from the physician assistant program, and this is going to be his first job. And he's for whatever reason, is going to work with a ENT physician. So I understand that this can work if he has a lot of supervision to begin with and learns how to do, the certain procedures which are, not too dangerous, and somebody's watching over what he's doing. But this seems to create a situation where I don't have the confidence that he's going to get the supervision in the early years.
Yes, Representative
start with,
Fellows,
so.
physicians assistants do get specialty training of various sorts as part of they do rotations the same way doctors do.
Oh, okay.
So they might have, we would hope that somebody right out of school would have completed a rotation in the specialty they're going to work in.
Okay.
Training is available.
And may I, Madam Chair? So the chair is correct. So they have thousands of hours of clinical training before they even are allowed to practice. The same as nurse practitioners who do not have any supervisory requirement. They can come right out of school, and frankly, they can open their own practice. So with the PAs, as the chair indicated, in addition to the thousands of hours of clinical work that they do before they are licensed, they also do have a rotation in various specialties. I would also submit that we're not changing anything that's happening right now. So the scenario that you present is exactly what's been happening for decades. We're not changing anything here. So right now, you could go to your ENT and you might have a brand new PA who you're seeing. But that PA has, as I've said, had thousands of hours of training. They've had the specialty training, and that physician who has employed that PA is going to be, especially if they're new, they'll be a lot more inclined to be watching over them, and they won't be taking the training wheels if you will. So again, we're not changing. This bill doesn't change what's happening right now, and so I hope that provides some confidence.
So, yeah. So I understand that the procedure can be the same if the physician is adequately, I'll use the word supervise, for that new PA, but it kind of seems like it takes the liability, and if he's not well trained, the physician assistant may do something incorrectly and cause a issue
Yes,
because he wasn't trained.
that's why they have
sufficiently.
liability insurance. And that's why the practice, if the physician, the supervising physician is involved, they are also liable.
So this would apply to a nurse practitioner, or a PA. At some point, everyone is new. And I'm not even talking about what's in the bill. The bill represents what is current law. The only thing the bill changes about any regulation is that we're not sending a document to Concord anymore. We're keeping it we're taking two documents that must exist per law and regulation, and we're combining them, and we're just saying they need to be kept at the practice, and that's all the bill does. So right now, there's a practice. All PAs must have a practice agreement with their employer if it's an ENT or whoever. Right now, that practice agreement is kept on file for inspection at the place of employment. Their responsible supervising physician is a separate piece of paper, and that is sent into the Board of Medicine. All the bill is doing is taking those two things and combining them, and calling them a collaboration agreement. So nothing is changing between what's in current law, what's happening now, and going forward. And again, the way that PAs or nurse practitioners or any healthcare provider provides care and how much what they're allowed to do will not change under this bill. That remains unchanged.
Thank you. Representative Lekis?
Thank you. So concerning the professional liability insurance coverage, I'm just wondering if whether the PAs that are currently practicing are either required to have this for other reasons or whether they pretty much universally do. What I'm getting at is this a change for any existing PAs?
So the answer is yes and no, if I may. Right now, no healthcare provider is required to cover any professional liability insurance, malpractice insurance, period, in state law or regs. No one is required to do that. This bill would be a first. This would require that of PAs and PAs only. And this was at the suggestion of the trial lawyers that came up during the Senate. And so the PAs, and now to get to your other point, anyone would be foolish to not have adequate liability insurance, but as the trial lawyers point out, there are the foolish among us. And by the way, in this instance, no physician would be foolish to sign an agreement with a PA if it's the current RSP or the collaboration agreement proposed in this bill, same difference, they would never sign an agreement with a PA that doesn't have adequate liability insurance. But nonetheless, as we all sit here in this room, we think that would be the case, but there are instances where people have not. So the physician assistants agreed in an effort to maintain consensus on the bill to accept a liability, a requirement in law that they carry adequate professional liability insurance, and that the definition of adequate be determined in rulemaking by the Board of Medicine. The physician assistants would love to see that apply to all healthcare providers, as you might expect. They don't think that they should be singled out, but being quite candid with you, Representative, we agreed to this change that was put forth by the trial lawyers in an effort to maintain consensus on this bill.
All right, thank you.
Representative Judy?
Morning.
Could you please explain me the difference between a PA and a nurse practitioner?
Sure. Well, nurse practitioners were trained as nurses. PAs, and I'm generalizing here, so bear with me. And again, I'm just a lobbyist, so I will let you know if I think I'm saying something I believe I know to be the case. But nurse practitioners were trained as nurses, and then they went on to get the extra education and training to be nurse practitioners. They come out of and they can practice independently with no supervision agreement or anything like that. They can open their own practice day one out of school. Physician assistants are trained in the physician model. I'm not saying they're trained as physicians. I want to be very clear on that. But they are trained, and there's folks in the room that can correct me. But they are trained in the physician model, and they go through. And I'm not saying that nurses don't. I'm just speaking more to what the PAs do. in that physician model, they go through all the various rotations, the clinical hours, et cetera. They just simply don't have the extent of the education and whatnot that a physician does. And so that, I think, but of course, when they're done with their education, they are not allowed to practice independently at any point in time. In some states, that's changed. They are allowed at either immediately or at some point in time to practice independently. Not the case. Not the case with this bill currently or going forward. That's the real difference. It's really just that there is two different education models. Nursing versus the physician model, and then there's the fact that when they're out of school, PAs can't practice independently.
Thank you. Representative Zitek, you had a question?
Mr. Cuzzy, I was concerned about liability for this reason, and you've uncovered it. Could it be that the trial lawyers are insisting on this coverage because doctors have more assets than a physician's assistant might
Representative
possibly?
Zitek, please do not speculate on people's motivations.
Thank you.
Representative Grota.
Thank you, Madam Chair. So in essence, since this bill really doesn't change the way people be between physician assistants or practicing, this bill, therefore, in a 1,000-foot view, is removing the Board of Medicine from certification of these physician assistants, and the relationship between the Board of Medicine will be between the physician who has signed this collaboration document with the physician assistant. Is that correct?
If I may, I'll not exactly. The Board of Medicine does not in any way, shape, or form approve or certify the current RSP, that responsible supervisory physician agreement between PAs and physicians. So there's no approval process from the Board of Medicine right now, regarding that relationship. All that happens is that piece of paper gets mailed to Concord, gets mailed to the Board of Medicine, and is kept on file. That's it. There are no. The board does not certify any educational programming or anything along the or accreditation of PAs. There is a PA on the Board of Medicine. The Board of Medicine, they maintain all of their regulatory authority over PAs under this bill. The only thing that changes in terms of what the Board of Medicine does or doesn't do is that they now don't get that piece of paper. That piece of paper would be combined with the practice agreement and just simply kept on file at the place of employment.
Follow up. I'm sorry. I phrased my question incorrectly.
Okay.
So the bill repeals the rulemaking authority of the Board of Medicine. It repeals several things. Why is that necessary?
Well, because so I think you're referring to the last page of the bill. So a lot of these are being repealed because they're not needed. So, for example, if you go to the front of the bill, with continuing education and with I'm sorry, I wasn't. I'm just trying to answer your question accurately without misspeaking, or with any kind of it mentions on page 2 of the bill, for example, on line 20, this Committee on Allied Health Education and Accreditation. That doesn't exist. So that is the rulemaking authority. Those rulemaking authorities are what are being repealed. So those are the issues that are being addressed in terms of rulemaking that are stipulated further in the bill. It's just to conform with what's being said elsewhere in the bill. If I hope I'm being clear. I apologize if
No,
I'm not.
you are. Thank you.
Thank you.
Okay, thank you. Yeah, that was my question, is does the Board of Medicine have general rulemaking authority over physician assistants?
Yes, ma'am.
Okay, because these appear to be very specific, and the bill puts them in statute rather than in rules.
Yes, ma'am.
Okay, thank you. Are there any other questions for Mr. Cuzzy? Seeing none, thank you very much.
Thank you.
Michael Padmore?
Good morning, Madam Chair, members of the committee. For the record, my name is Mike Padmore. I'm the Director of Advocacy for the New Hampshire Medical Society. I'm here today to speak in support of SB 228. I want to start by thanking the New Hampshire Society of Physician Assistants for coming to us last fall to discuss this bill. Since I've been in this role since 2018, we worked very, very closely with the physician assistants to make a couple common sense changes to statute and to rules. A couple examples of that were removing ratio requirements that PAs and physicians had, and then also removing the requirement for a PA to have an RSP named prior to licensure. So when they came to us with this bill, we really wanted to figure out a way to work with them and understand the things that they were trying to accomplish with it, and figure out how we could kind of bring all the different stakeholders together to come to an agreement. And I do think that this amended version of this bill does reflect the concerns and the changes that all of those stakeholders wanted to make. So I'll be brief, and I don't want to be redundant. I think Senator Bradley and I think Mr. Cuzzy did a good job of explaining what's in this bill. So I'll just thank the committee for their time, and would be happy to answer any questions that folks might have.
Thank you. Representative Sitek.
I'm not sure if this is for you or Mr. Cuzzy. This agreement that no longer gets sent to Concord, the RSP, I guess, is now kept in a file cabinet in the physician's office, medical practice. Who actually gets to see it? What's the purpose of it? Who examines it?
So I think my understanding would be that that document is required to be held if the Board of Medicine does request it. Prior, I believe, the RSP that was sent to the Board of Medicine to be kept on file there. In this new revised edition, I believe the Board of Medicine's been consulted on this. They don't need to have that unless they do request it. So if they request it, then that collaboration agreement can be sent to them.
Yes, follow up?
Does the bill say that they have the right to? Who has the right to see this by statute?
I believe it does say in statute that upon request will be sent to the Board of Medicine. I can double check that, but I believe it's in there.
It's page 3, line 20. Representative Pearson?
Thank you, Madam Chair. The agreement that we're beating to death here, is that something that an insurance carrier would require to see as part of their, I mean, I know you're not an insurance guy, but is that logical?
I appreciate the question. I don't know if I can really answer that. I don't know if I can answer that.
Thank you, Madam Chair, and thank you, Mike, for taking my question. I'm asking this, although I think I know the answer, because I think it needs to be on the record. My understanding as a hospital trustee is that sometimes it is difficult to get physicians to agree to sign these collaborative practice agreements for a variety of reasons. Will this bill address our difficulty as a hospital in attracting physicians assistants, because we will no longer have that difficulty?
Thank you for the question. I certainly would hope so. I think one of the goals of the physician assistants in proposing this legislation to start was to hopefully streamline that process and make that that hiring process a little bit easier for physician assistants, and that relationship between PAs and physicians a little bit more streamlined. So I certainly would hope that that is the case.
Thank you.
Thank you. Other questions? Thank you very much.
Appreciate the time.
Marissa Chase.
Good morning, Madam Chair, members of the committee. For the record, my name is Marissa Chase. I represent the New Hampshire Association for Justice, which is a euphemism for the Trial Lawyers Association. We are a statewide professional association of approximately 400 attorneys focusing on representing plaintiffs and plaintiffs' rights. I wasn't planning on speaking today. I appreciate the physician's assistants and the Medical Society and the Hospital Association, all the hours that they have taken to talk with us and come to consensus. I do believe the bill before you is a result of that consensus. I just wanted to point out a couple points based on questions that I heard of committee members, if that's all right. NHAJ is neutral on the bill. You know, I think any expansion of access to health care for patients in New Hampshire is a good thing. But I think it's important to recognize that PAs, inherent in their title, physicians, assistants, and other mid-level healthcare providers, were never intended in our overall regulatory and statutory and licensing schemes to practice independently. So I think it's important to bear in mind those are the reasons why we requested those changes. Adequate liability coverage is typically in a requirement in a hospital's credentialing agreement. So that's how it happens now. By calling it out in statute, because it's foreseeable that some physician assistants would no longer be under the umbrella of a hospital as they typically are now, we felt it appropriate. We were very happy that they agreed to that change. As Mr. Cuzzy said, you know, it would be foolish in this day and age for someone to not cover adequate liability coverage. Unfortunately, our members have seen that to be true. And that is only when a patient is so egregiously harmed by the acts of a healthcare provider, which is rare. I want to point out it's exceedingly difficult to bring a medical malpractice suit, especially in New Hampshire. We have very conservative juries and verdicts. We do not have, punitive damages in New Hampshire. So that keeps our jury verdicts low. And I also want to point out, especially with this committee, that I haven't been before you before, especially with the pandemic. In New Hampshire, how a plaintiff's lawyer brings a civil suit, they take it on what's called contingency fee. That means that the lawyer does not get paid if and unless they prevail, which means that they are financially incented to not take a case that doesn't have very clear liability or high damages, you know, potential future loss of income, loss of enjoyment of life, etc. Contingency fee also means that a lawyer fronts all the costs of litigation up front. That means that they are responsible for fronting the costs of experts going through testimony, deposition. We're talking thousands and thousands of dollars. So we do not have a frivolous lawsuit issue in New Hampshire. I just wanted to, you know, kind of clarify that for the record, and I'd be happy to take any questions.
Thank you very much, Representative Marsh. And please don't ask questions you know the answers to.
Okay, well, that might make it difficult. Thank you for coming to testify before us today. As this bill is written, are the collaborative practice agreements discoverable if a case goes to trial?
That I don't know. I'd be happy to follow up with the committee.
I would appreciate that.
Okay. Other questions? Seeing none, thank you. Excuse me, Representative Fellows.
So right now, if a physician's assistant did something that was bad enough that there'd be a possibility that they're sued for it, can you tell me who they would sue now and how this bill would make that different? And I'm just generally trying to, do physicians always have their own insurance, or is it sometimes covered by the hospital or wherever they work? Who covers the liability for all the different options right now versus under this bill?
So unfortunately, I'm going to give you a complicated answer, which I don't like doing. It depends. I mean, it depends on the case, the specifics of the case. There's what is a complicating factor. I think plaintiffs' lawyers get a bad rap, and I get it, but plaintiffs' lawyers typically get, I think, blamed with naming so many defendants in a lawsuit, like anyone who could have touched anyone in the process. In New Hampshire, it's not always the plaintiff's attorney who is naming other defendants, because we have a case called De Benedetto, where I'll breeze over it. I'd be happy to follow up with the committee with the, the many pages of
Just the
case.
highlights,
Just the
please.
highlights. A defendant can shift blame onto other defendants, and they can name other defendants in a case because, say, I'm a patient, I had surgery, they cut off the wrong leg, God forbid. I sue the doctor who did the surgery, and the surgeon says, well, it was actually the radiologist who gave me the wrong information, or it was the hospital, and they are able to name other defendants. So it's not always the plaintiff's lawyer naming all of these parties and bringing everyone in, and that's true across the board in civil cases in New Hampshire. I don't know if that answers your question.
Mr. Cousins, you have a better, more closer to the question, an answer closer to the question.
Yes, ma'am.
Please.
Thank you. So right now, a physician assistant can be sued for the care they provided. When a physician assistant is sued, the physician that is on that, what it currently is that RSP form, can also be sued simply because their name is on that form, even if they had nothing to do with the care that was provided. A PA would not be involved in performing surgery necessarily, but I'll, for simplicity's sake, Madam Chair, if you will, say a PA sees someone at an urgent care center because they have a strep throat, and for some reason, and there's no reason for the PA, they look at the throat, they confirm it with strep, they provide the antibiotics, and that's it, a fairly straightforward interaction. The PA does not need to consult with anyone on the care of that. But that patient sues. They could certainly sue the PA. They can also sue the physician who is the responsible supervisory physician for that PA right now, even though that physician had nothing to do with this basic interaction. So what we're saying in this bill is that may not make sense. And so what we're saying is that physician should no longer be able to be sued if they had absolutely nothing to do with the case, just because their name is on a piece of paper. The PA absolutely still will be sued. What the bill makes clear, though, is that if there was any kind of involvement from that supervisory physician, or any physician for that matter, if they simply asked a question, said, geez, I do see a little of this as I look down their throat, right there, right then, now that brings liability upon the physician. And so we're just making clear that just because your name is on a piece of paper, you don't get sued. But if you have anything to do with the care of that provider, you absolutely still are liable for in that instance. PAs don't lose their liability that they have now under this bill.
Thank you very much for the explanation. All right. And yes, Representative Schmidt, Representative Allegro.
Does the physician not have to do with that error or damage if they hired that physician's assistant?
No, I think, that's, and correct me if I'm wrong, but, these, any malpractice type situation is determined based on that interaction. I suppose if you're talking about a private practice, then if there were a lawsuit of some sort, I'm sure that the practice itself would be named in a suit. But if you're talking about, let's just say someone goes to the Elliott, to one of their urgent care centers, and they see a PA, then, but the physician who is the responsible supervising physician, or in this case, the collaborating physician under this bill, they have nothing to do with the care under the scenario I painted for Representative Fellows. That physician would not be sued, but I'm sure that the Elliott, as the employer of the PA, would be part of the lawsuit. That's just speculation.
I think we're all speculating a lot about lawsuits. So I would, yes, Representative O'Brien.
Thank you, Madam Chair. I don't care about lawsuits, but what I hear here from your explanation, you know, as a deputy, my former job as a deputy fire chief, I used to read the reports and just to make sure that everything was adequate, that the companies were behaving within the training and procedures. By eliminating this, in other words, no physician's got to review and say, oh, I think you might have got this wrong reading the report. You should probably call the patient back. Is that eliminating that? A supervisory look at it, a second, like a doctor overseeing?
Thank you for the question, Representative. This bill does not change anything in terms of how a physician and a PA interact. It doesn't change how an employer would require a PA and a physician to act.
Other questions? Representative Schmidt.
Do we have further witnesses, Madam Chair?
No. We have, that's the last pink card we have. I'm going to ask if anyone else wishes to speak, but we've already spent more time than anticipated on this. So unless you have a serious question, do you? No? Okay, thank you. Representative Goley.
Thank you, Madam Chair. I was hoping there would be someone else coming up, but I will ask Mr. Cuzzy. On here, it's struck that the individual must maintain current national certification if required by a national certifying body. Why was that struck, and is that no longer applicable? Do they not belong to any national certification?
I don't have the bill in front of me, but those were, what the bill was looking to do was remove entities that, or references to certifications that do not exist. And that would be a situation there, as I heard it, as I'm remembering what's in the bill. If I can just grab my copy behind me.
On page 2, line 27.
Yeah, there is no national certification that exists, and that's why that was struck.
Any other questions? Okay, thank you very much.
Thank you, Madam Chair. If I may, I just want to clarify, I do not believe that anybody has ever been sued for misdiagnosing strep throat in the state of New Hampshire. And I will be following up with the committee with some information that's hopefully helpful, and then you'll have my email address, and please feel free to send me any questions.
Thank you very much for that additional information. Representative Schmidt.
I don't believe you indicated it, whether your organization is in support of this bill or you're testifying.
She said that they are neutral.
You are in support. Thank you.
Representative Schmidt, they are neutral.
Yes, thank you.
They are neutral. They're not in support. They're in neutral.
That's what I said, yes. Okay, is there anyone else who wishes to testify on Senate Bill 228? Okay, seeing none, I'm going to close the hearing, open the hearing on Senate Bill 277, and call Peter O'Neill for Senator Hennessy.
Good morning, Madam Chair and members of the ED&A Committee. My name is Peter O'Neill, for the record, and I am the legislative aide for Senator Erin Hennessy from District 1. Unfortunately, she cannot be here today, and thanks to you all for the courtesy of letting me introduce her bill on her behalf. So last year, the legislature took a close look at the emergency orders issued during the pandemic to see which should be codified into law when the state of emergency lapsed. The result was Senate Bill 155, which, among other provisions, extending the Temporary Health Partners Program and gave the Office of Professional Licensure and Certification to issue emergency licenses to in-demand medical providers. That authority and those licenses should have expired on January 31st, but the OPLC was able to go through rules for a short-term extension. Senate Bill 277 simply changes the date until which the OPLC can issue licenses from January 31st, 2022 to January 31st, 2024. Since the beginning of the pandemic, 22,000 individuals not previously licensed in New Hampshire have been granted emergency licensing status. This program is working. We should extend it 2 more years and give the next legislature time to consider this streamlined licensing authority should be repealed, extended, or made permanent. We all know how important this has been for the state of New Hampshire, given how difficult it has been to find healthcare providers in these times. If you have any questions for Senator Hennessy, I can make sure she gets you an answer, but I would largely defer to OPLC and the healthcare providers here in support of this bill. Senator Hennessy thanks you for your consideration and support of Senate Bill 277. Thank you very much for your time.
Thank you. I don't think we'll have any questions at this point, so, but we will reserve the right to communicate with you if we do.
Thank you very much, Madam Chair.
Kate Horgan.
Good morning, Madam Chair. My name is Kate Horgan. I serve as the Executive Director for the New Hampshire Association of Counties, which is all of your elected and appointed officials. This bill is very simple. As Peter explained, it puts temporary healthcare licenses into the statute for another 2 years. Temporary healthcare partners in our county nursing homes have been vital as we continue to work through our workforce shortage, and we would urge the committee to support the bill. And I'm sure OPLC will have lots more detailed answers for you, but I'm happy to take any questions that you have.
Which professions are getting these emergency and temporary licenses?
I'm sure OPLC can tell you all of them, so I would direct it to them, but I do know that they are working in the nursing homes.
Other question?
Thank you.
Good morning. For the record, my name is Jessica Kalapolitis. I'm the Director of the Division of Enforcement at the Office of Professional Licensure and Certification. I am here on behalf of OPLC, and OPLC does support the language of Senate Bill 277. Our Executive Director, Lindsay Courtney, provided written testimony which provides greater detail, which I'm not going to repeat here for you. But I would be happy to answer any questions that the committee might have.
Thank you. Are there questions? Representative Goldie.
Thank you, Madam Chair. Why do they feel the need to take it out to 2024?
I'm not exactly certain of why it was taken out 2 years, why it was that length of time. I can certainly follow up with the Executive Director and get back to you on that.
Thank you. It is 2 years from 2022 to 2024. Yes. Yes, thank you. Representative Allegro.
Thank you, Madam Chair. I just want to make sure I'm not misunderstanding what I expect is actually a simple concept here. Right now, there's a temporary situation that was triggered by the declaration of a state of emergency. That arrangement is set to expire, and the goal here is to extend it for 2 years. And so my question is, since you've answered the first ones with nods, my question is why not seek to make it permanent now based upon subsequent declaration of an emergency? I'd like a little insight. Thank you.
Certainly, I can I can attempt to answer that to the best of my ability. I may have to follow up on that one as well. But my understanding is that although healthcare workers who had these temporary licenses had the opportunity to seek full licensure, many of them did not. There is a concern that if those licenses are to expire and are not extended, that would have a negative impact on the workforce in healthcare in New Hampshire. So that may be partially why it was looked to be extended, because they can seek full licensure, but many of them have not for various reasons. But again, I can follow up with the executive director to get a more detailed response to you on that.
That's what concerns me, is that we had a separate bill to consider the qualifications of people who are getting these licenses. And I'm very concerned that there are people who are actually not applying for a permanent license because they wouldn't qualify. And I don't know if we want to do that. Also, I'm very concerned that you're talking about on line 8, you're applying this retroactively, and I don't believe that's constitutionally allowable. Right. Other questions? Representative Goldie.
Thank you, Madam Chair. I'm also looking at on the first page on line 13 down through as to why are we not charging a fee for a mail-in pharmacy license? Why is it at no cost?
I apologize. I'm going to have to follow up on that as well. I don't know why there's no cost. It may have simply been part of the emergency process to get it in place quickly. That would be extended, but I will follow up and get you a better answer on that.
Thank you, because if we're going to extend this for almost 2 years, I think they should be paying.
I would tend to agree, since that's a fairly hefty license fee. I take it that none of the individuals who applied for these licenses paid any kind of a fee?
I don't know if there was a fee. I apologize. I don't.
Okay, thank you.
Yep.
Yes, Representative Pearson.
Thank you. As we've worked our way through the COVID-19 pandemic, and as we've discussed both in this committee and as a legislative body, we have different, I guess, opinions on what constitutes emergency action versus management. I would argue we are well into the management phase of this. So from a management standpoint, OPLC certainly, and this is a question, I would presume has the kind of the management of all this kind of down pat by now.
Are you referring to the administrative processes involved in issuing these licenses?
I'm referring to the administrative processes of these emergency provisions that were put into place during the emergency phase of the COVID-19 pandemic. So,
yes.
So you've kind of got this down. You're chugging along, in other words.
Yes.
Okay.
Okay. Other questions? Representative Schmidt.
Thank you, Madam Chair. So you've been put in a somewhat difficult situation here, testifying on behalf of OPLC. Is this bill going to have some kind of a subcommittee so that we can have, sorry, see you from where I'm sitting, so that we can have access to the executive director who has the authority in this matter and probably ought to be testifying before us?
I don't know. It certainly appears to be much less straightforward than I thought when I first read the bill. and
I think it's pretty straightforward in one respect, but it probably not going to meet with much approval on the part of the committee, given the fact that there are questions that have already been raised that need answers, and
Yes.
Ms. Kalapalides is not in a position to provide those answers.
yeah, good point. Representative Goley.
Thank you, Madam Chair, and I just want to state my concern as well, especially if you look at the numbers in the fiscal note, fiscal year 2022, a loss of almost $700,000 in license revenue is a concern.
Yes, I mean, I would suggest that some of the people that did not apply to permanent license looked at the license fee and said, why bother? I can get a free license. So, that's it. As opposed fourth. Yes, exactly. Representative Fellows?
I don't know if you know the answer to this or not. I'm just wondering if the license for the pharmacies that's being extended would have, if that has, that emergency licensing has anything to do with the availability of the COVID vaccines.
My understanding is that it does not. My understanding of the permits for the pharmacies has to do with clinical trial participants who would get the clinical trial drugs from a location in Massachusetts. So that would be an out-of-state pharmacy, but they're unable to travel there. So it would allow them to still have access to those drugs.
Thank you.
Okay. Thank you. I think Representative Yakubovich, your subcommittee should at least meet and discuss this, possibly with some of the, when we get the questions answered. Are there any other questions? All right, seeing none, thank you very much for your testimony. Is there is there anyone else who wishes to testify on Senate Bill 277? Okay, seeing none, I will close the hearing. And yes, Representative Goldie?
We did receive a letter from Director Courtney. So if anyone wants to take a look at it, you should have it, and it tells a little bit about the emergency order for pharmacies.
Okay, well, thank you. That's helpful. All right. We have a few minutes before our next hearing, so we'll take a...
There was some written testimony passed out by Ms. Horgan, but there weren't enough copies for all the members. At least they didn't get over here.
Being 11:15, I'm opening the hearing on Senate Bill 284 and calling Senator Ward.
Good morning, Madam Chair and members of the committee. For the record, I'm Ruth Ward, Senator for the District 8, and I'm here today to present to you Senate Bill 284, which is a request of the New Hampshire Optometric Association, which represents over 180 doctors of optometry in New Hampshire. Unlike other similar doctorate level independently practicing health providers, the optometrists' so-called scope of practice and the diseases they treat is dictated by statute. The current statute relative to treatment of glaucoma was put in place in 2002 and authorizes treatment of primary open-angle glaucoma. Glaucoma is a disorder of the eye characterized by increased intraocular pressure that may cause impaired vision, ranging from slight loss to absolute blindness. Much has changed since 2002, including the statutes in most states. New Hampshire is the only one of 3 states that do not allow treatment for all glaucomas by optometrists. Senate Bill 284 will amend the statute to allow optometrists who are certified by the state board to treat all glaucomas. This has the benefit to patients who no longer will need a referral for a separate health care professional to treatment of a disease that the optometrist is perfectly capable of treating. It will also assure that top-notch optometrists will practice in New Hampshire rather than another state where they may practice to the fullest extent of their education and training. This bill makes 2 other related changes to the glaucoma statute that the optometrists here will provide details on. I know optometrists today are educated, well-trained, and capable of treating New Hampshire patients as this bill allows. And I ask the committee to recommend ought to pass on this common sense legislation. Thank you.
Thank you, Senator. Are there any questions? Seeing none, thank you very much.
Thank you.
Okay. Allison Laranger. You gave it. You indicated you have written testimony. Have you sent that to us previously?
Yeah, Madam Chair.
Also, feel free to
Representative
turn your
Jacob-
microphone on.
Okay, so it's
Is it
coming
on
around.
now?
Thank you very much. No problem.
Okay. Are we all set? Okay. Well, my name is Dr. Allison Laranger. I was born and raised in Bedford, New Hampshire. I currently live in Goffstown and practice full-time in Manchester at New Hampshire Eye Associates. I started my career in Rhode Island in 2010 and then moved to my dream state, Colorado, in 2012. My parents' health began to decline in 2019, so my priorities changed, and I moved back to my home state where I intend to finish out my career. It had never crossed my mind that I'd be coming home to a restrictive glaucoma law. I fully expected to practice optometry as I had since graduating in 2010. The reason I was so surprised was because after graduation, I landed my first job at a private practice in Rhode Island and started treating glaucoma without restriction. I did not have to clear cases with other providers or have anyone check my work. The same was true in Colorado. I also treated secondary glaucomas in both states from day one. In fact, New Hampshire has the most restrictive glaucoma laws in New England and is one of 3 states in the country that cannot treat secondary glaucomas. On top of that, I learned that despite having treated full scope glaucoma independently for 9 years and studying it extensively in optometry school, I was required to consult with an ophthalmologist for all new glaucoma cases for a full 2 years after receiving my New Hampshire license. And since every glaucoma patient was technically new to me, the ophthalmologists in my practice were burdened with having to review every single glaucoma patient that I saw. This is the same for every doctor moving to this state or new licensee in general.
since every glaucoma patient is new to them. This rule is outdated and is not in line with our modern education and the length of time that optometrists have been treating glaucoma. In this state and around the country, optometrists have been treating glaucoma for more than 20 years. Optometrists are doctorate level providers with independent licenses to practice, and we're not required to be monitored or have sign-offs for anything else that we do. We have prescriptive authority for oral and topical medications, including controlled substances. We order MRIs, CT scans, ultrasounds, stroke workups, blood work, etc. I needed to come home to New Hampshire for the sake of my family. But a lot of optometrists have a choice of where they want to practice, and it makes sense that when choosing a job, they will weigh New Hampshire's current restrictions versus the ability to treat glaucoma fully to their level of education and training. Passing this bill will undoubtedly open New Hampshire to more candidates for the healthcare system and more top-notch eye care providers for the community. And that is all I have for today, but I want to thank you so much for listening to me and for serving our state. And I ask that you please support State Bill 284 to bring our laws into alignment with our modern training and the rest of the country. Thank you.
Thank you very much. Are there questions? Amazing. Thank you very much. Winnie Sang.
Madam Chairman, members of the committee, I'm Dr. Winnie Sang. I'm an optometrist and have been in practice in New Hampshire for over 20 years. I'm one of the owners of a group practice in Littleton, Woodsville, and Lincoln. I am here to give you some of my insights through another set of optics with regards to SB 284. Being in the North Country and in a rural setting, our practice is the go-to practice for primary and medical eye care to our communities. We treat a myriad of eye conditions and diseases, including glaucoma. But for many years, I did not have the authority to treat glaucoma independently because I graduated in 2001. If I may ask you to refer to page 1, lines 12 to 13, those line items pertain to me and some of my colleagues who graduated before 2002. As you know, under the current statute, optometrists who graduated prior to 2002 have to go through a tedious and logistically difficult process of obtaining therapeutic glaucoma certification. To clarify the context of my testimony, please refer to page 1, lines 24 to 28, and page 2, lines 3 to 4. As referred in those lines, I had to have 25 cases of only one particular type of glaucoma that I had to have my fellow ophthalmologist co-manage with me. Our patients in the North Country would travel 1 to 2 hours to meet an ophthalmologist face-to-face for a set period of time to prove co-management of these cases have been reviewed by the ophthalmologist. And these cases had to be for only one type of glaucoma, primary open-angle glaucoma. And as you may know, there are many types of glaucoma we have been trained to treat, but we could not use the other types of glaucoma in our cases for the certification process. This is one of the reasons it took me many years to attain certification status. Other reasons were my co-managing ophthalmologist retired, and then another one relocated, and on occasions, patients relocated, in which case I had to start over again. It was a process that was unnecessary to not just me, but to the patients I served, because a number of them did not want to see another eye doctor for providing the same care I provided for them. I actually contemplated moving to another state in the beginning of this process, because if I were practicing in almost all other states of the country, I would be able to treat glaucoma independently, regardless of when I graduated, as I was academically and clinically trained to do. It's ironic to note the associates in my practice who graduated later than I did in 2002 onward. With the same education I received, were able to independently treat glaucoma without the restrictions I had. Needless to say, those restrictions impeded not only access to quality of care to our patients, but timely quality eye care. Since I had to co-manage with a sponsoring ophthalmologist, and due to the fact there are only a couple of ophthalmologists in our neck of the woods, the limited number of ophthalmologists means patients had to wait, sometimes too long, for a co-management appointment with another eye doctor who would be managing these glaucoma cases the exact same way I was managing them. These duplicative care scenarios are inefficient to our healthcare system. And more importantly, it does a disservice to our patients as we fail to provide a timely access to care. You may ask, how will SB 284 benefit the patients? SB 284 would take away the burden on our patients in that they will be provided with a timely, quality eye care that would be sustainable to our healthcare system. If co-management is needed with an ophthalmologist, like in my experience, a face-to-face encounter is not mandatory. This is especially helpful for our rural patients who are not eager to travel hours to get duplicative care. SB 284 is a patient-centric, modernized bill that would ensure we are reaching closer and closer to our goal on preserving the eyesight of our glaucoma patients, because there is going to be quality eye care that is easily accessible for the citizens of New Hampshire. By increasing access to care to highly trained and qualified optometrists, patients will be reassured their local eye doctors are ready to provide them with the highest quality eye care they deserve without the burden of long travel and wait times. I thank you for your consideration.
Okay, will you answer some questions?
Sure.
Representative Schmidt?
Thank you, Madam Chair. So, Doctor, can you tell me or estimate what percentage of, I'm over here, ma'am, to your left,
Oh, I'm sorry.
right over here. Thank you. So can you estimate what percentage of the overall patient population that you might have been able to serve, but without restriction, had the law permitted it? What reduction in ability to provide the totality of service that you should have been able to provide as of against what you actually had to do because you had to get an ophthalmologist involved and reschedule and go through the whole other rigmarole you described in your written testimony. I hope you've already provided it. Thank you. Can you give us an estimate of what kind of loss to your practice you experience as a result of the current situation that still exists?
Thank you for your question. What I see is it's not a loss to our practice. It's more a loss to the patient's wait time and the care that they could have gotten, had they gotten access to care. Right now, the wait time to see a fellow ophthalmologist for co-management is more than, it could be more than 6 months in some cases in Dartmouth and around our neck of the woods. There's, only a couple of ophthalmologists I could access that kind of co-management with.
Thank you.
Jewett?
Thank you, Madam Chair. Thank you, Doctor. Could you just briefly give us an idea of the timeliness that's necessary to do treatments such as you're talking about?
Sure, I'd like to answer that question. So the kind of glaucoma that we see are a myriad of glaucomas. There are some types of glaucoma that require urgent treatment. You know, we cannot wait 6 months, depending on the stage of glaucoma that a patient may encounter. And so every case is different, but, you know, we always want to think about preserving people's vision and their eyesight and the, you know, the timelier care they can get and, you know, in the care that they deserve, the better. And, you know, if just think of it as if it were your mother or your sister and, you know, they had just been diagnosed with glaucoma and you can't, at this point, manage it without them seeing anybody. You know, it may not be an emergency situation where they had to come and get care within a day, but in their mind, you know, they're already diagnosed for glaucoma and they want that treatment as soon as possible. And as I would if I were a patient and I was just diagnosed with a condition that could be vision threatening.
Okay, thank you. Representative Sytek?
What will trigger your referring someone to an ophthalmologist? Let's say you are doing glaucoma treatment and the pressures don't go down or something is wrong. When do you?
It is specified in the bill. Is there any other questions? Representative Bailey?
Thank you, Madam Chair. So the part that would allow a 2001 graduate or before to proceed is this bolded line that says you're instead certified by the American Board of Optometry. That's what it would allow. That's the fix.
Would you mind clarifying that
it's on
question?
line 15 of page 1. It mentions the 2002. You said you were a 2001 graduate and you had all these problems. I
Right.
could see that the jump start for not having that problem is 2002, and they've added or who are certified by the American Board of Optometry. That's the fix, is it?
So yes, what we now have, you know, American Board of Optometrists who are certified as fellow optometrists, and you know, having that fellowship status means that they have, you know, extra continuing education that would allow them to be able to treat glaucoma, and I am one of those optometrists.
Yeah. Thank you.
Representative Judy and then Marsh.
Yes, thank you, Madam Chair. Good morning, Doctor.
Good morning.
Right now, are you allowed to do surgery?
No, we are not. We are not trained for surgery. We are primary care optometrists. We treat glaucoma medically, but we are not surgeons in the, you know, definition of surgery in the New Hampshire statute.
All right, thank you.
Representative Marsh?
Thank you, Madam Chair. This is a follow-up to the earlier question. The certification by the American Board of Optometry on page 1, lines 15 through 16, is that certificate time limited or is it given for lifetime?
The certification process is given to a lifetime. However, we are obligated to go through a continuing education process. You know, there are a minimum of hours that we need to attain every year to regain our licensure. Does that answer your question, sir?
Thank you.
I have a question. Actually, it may apply to the other one. It says that it looks as though current statute says the board may waive these requirements for someone who was licensed and practiced for at least a year. Is the board actually not waiving those requirements?
May I answer that question?
Oh, please. Oh, so you've got someone
Yes.
else?
Okay.
Okay, thank you. I wasn't sure who would answer it. Thank you. I'll postpone it. Any other questions? Representative Pearson.
Thank you, Madam Chair. Just curious as to what magically happened in 2002 to put a line in the sand between those prior and those after.
And so that's the year I graduated in 2001. And interestingly enough, soon after I graduated, we had a bill on glaucoma that, gave scope expansion to optometrists to be able to treat primary open angle glaucoma. But that would happen after that year the bill was passed.
Okay, no, that's not really what I asked. Or let me rephrase it. From a, let's call it an educational sense, was there a significant difference in the curriculum that one would go through in 2002 that changed? Why is this date in here?
I see your question. Thank you for clarifying that. There is no difference in education. Someone who graduated in 2001, like myself, has the same education as someone who graduated a year later in 2002. So it was, just one of those lines that they made when they passed the statute.
Makes no sense to that. Okay. Other questions? Seeing none, thank you very much. Ms. Hitchmoth? Dr. Hitchmoth, please. Since we have an open question.
Good morning. Thank you for letting me talk to all of you, and thank you for your service through the last couple years, which has been more difficult than usual, I think. Can you hear me okay now?
That's better.
Okay, great. I appreciate that. Dr. Dorothy Hitchmoth, I practice in New London, New Hampshire. I've been practicing in the state for over 25 years. I'm obviously here representing the New Hampshire Optometric Association. I'm also on the Board of Trustees at the New England College of Optometry and can answer any questions about education. I was also present for all of the negotiations, if you want to call them that, when the bill was originally passed, both in 2002 and prior. So I will answer your question hopefully more directly and say that I agree with you. It makes no sense. And as all of you know, that when legislative compromises occur, they often make no sense. So the training of doctors of optometry really hasn't changed since before I graduated, which is a lot longer ago. And I will affirm that there were many, many states already in the country that allowed full scope of practice in regard to the treatment of glaucoma, which is a single eye disease, by the way, happens to be a sight-threatening eye disease. So even in 2002, so we were already behind the 8 ball at that time, and I was physically present for all of those negotiations, and will tell you that the only way that we were able to compromise and pass the bill at that time was to allow for this secondary process to be implemented. And that secondary process is what you're reading in those long 2 pages in front of you. So for those individuals, those doctors who had graduated, who had not served for a year or did a residency for a year or served in the Department of Veterans Affairs for a year, would have to go through another iterative process because there was concern that there were all these doctors running around that somehow didn't have modernized training despite the requirements for ongoing competency and ongoing education through our usual processes. So in order to allay the fears potentially of those of you who have to make difficult decisions about scope of practice, which is a whole nother issue in and of itself, that was the compromise. With this bill, the essence of this bill is to remove some of those old restrictions. We are suffering in the North Country. I will tell you it is very, very difficult to recruit doctors. We have an access problem. There are 2 of us in my area and nobody for a 60-mile radius. The doc up the street from me has a 1-year wait list for just regular eye care. I won't speak on behalf of my friends in ophthalmology, but I have cataract surgeons that just simply don't have the time to see these patients when that opportunity or when that has to occur. They're booked out weeks and weeks. Dartmouth, the wait time is months for cataract surgery, for example. So we're injecting redundancy into the system that is just not necessary. And that's really what this bill is asking for, is to let's please eliminate the redundancy, especially in a state where we have so many rural areas with a perfectly qualified and educated group of doctors who have an amazing track record already, specifically in this state, and amazingly so across the country, in treating this one particular disease group. I'll tell you, there are more types of glaucoma. This bill specifically addresses what we call secondary glaucomas, which means that those cases are somewhat more rare, possibly more calcitrant to treatment, and may need surgical referral. But I don't think we need to legislate those types of things. These are things that happen naturally between referring providers if you're competent. If there's an assumption of incompetence, well, that's a different problem. So I hope I've answered a few of the questions. I will also add that I was at the Department of Veterans Affairs for 22 years that served the 2 northern counties in New Hampshire and treated full scope many, many, many veterans who I put on a much, who I have ultimate respect for and think we need to maintain the integrity of their healthcare system for a whole host of other reasons. But there were no restrictions to this effect on those veterans.
Yes, thank you. My specific question was that it looks as though on page 2, line 15, it says that the committee may waive or reduce these requirements for people who have a license and proof of practice for 12 months.
In another state.
In another state. But Dr. Laranger said that she had practiced 9 years in another state and still this was not waived.
So for her, it was waived, if I'm not mistaken. Yeah, so I believe it was. So there were a whole host of doctors who met by statute the waiver. I was one of them, right? So I was treating for years and years, and so I didn't have to go through this process. However, there's still, even for those of us who have had the waivers, there's still restrictions in the language that say you need to refer for a certain time period, which is onerous and nearly impossible, especially
So
in
I
the,
understand that.
Yeah.
I was just concerned that the certification committee or credentialing committee was not accepting out-of-state practice. Because it says may, and in many cases, we've had concerns with that.
Sure.
Okay, thank you. Representative Pearson.
Thank you, Madam Chair. And I greatly appreciate you coming before us with especially with your historical perspective on how we got to this. Does this, two things. Are you confident that this is going to accomplish what it's intended to do? First off.
Yes, this will expand the number of doctors that we have that will not have to refer based on the way the language is written right now. Do I think that there are some other unintended consequences? No.
Okay. And secondly, is there a simpler way to do this, or is this kind of just the way you got to pave this road?
I think this is the way that we have to pave this road. One thing that we didn't want to do as an association is go back and make it look like we were trying to expand our current scope of practice, because as you all know, that's a little more difficult pathway. So we didn't want to have to sacrifice patient care and access. And we thought this was really the most simple way to do it, was to just adjust the language as it's written.
Okay, Representative Schmidt.
Representative Pearson has asked my question.
How efficient. Are there any other questions? All right, seeing none, thank you very much.
Yeah, thank you.
Christine Donahue.
Good morning, Madam Chair and members of the committee. Before I get into my prepared speech, I do serve on the Joint Credentialing Committee, so I thought maybe I could speak to the waiver situation for a moment regarding Dr. Laranger's practice in a different state that had unrestricted privileges. And we are definitely granting waivers. However, as of now, the only thing that we can waiver is the initial certification process of the 25 co-managed cases. We are not able to do a waiver for the period after certification that every optometrist in the state, regardless of year of graduation or regardless of that if they've been practicing for 20 years in Rhode Island, we are not able to waive the 24-month requirement where they still have to refer every single new case of glaucoma. So it's really a two-tiered approach to how you get your glaucoma certification. You do the 25 cases if you were prior to 2002. That can be waived if you are practicing elsewhere. What cannot be waived, again, every optometrist, once they get that certification, has to still co-manage for 24 months, regardless if they graduated last year from optometry school. Does that clear that up for you?
Yes, thank you very much.
My pleasure.
So that lines 22 and 23 are the issue that they.
That is correct. And
Okay, thank you very much.
thank you. So, thank you for the opportunity to speak to you today in support of Senate Bill 284. This bill seeks to reduce unnecessary restrictions on the treatment of glaucoma by doctors of optometry in New Hampshire. Again, my name is Dr. Christine Cabin Donahue, and I am also a lifelong resident of Bedford, New Hampshire. Since 2009, I have been practicing optometry at Manchester Eye in Manchester, New Hampshire. I do currently serve as the newest member on the New Hampshire Board of Optometry, but I'm here today on my own behalf. Manchester Eye Associates was first started back in 1977 by my dad, Dr. David Cabin, and I am proud to be a second-generation optometrist in our state and feel as though I've spent basically my whole life in the field. I also remember my father attending many proceedings when the current glaucoma statute was passed in 2002. So 20 years later, it is my privilege to be part of this well-known update to the statute. During my professional career, I have treated a large number of patients with glaucoma. I know it's been touched upon, but glaucoma is a disease in which progressive damage to the optic nerve can result in permanent vision loss. About 3 million Americans have glaucoma, and worldwide, it is still the second leading cause of blindness in the world. It is very treatable, but has no symptoms often, so early detection and treatment are critical. When glaucoma was added to the optometry statute over 20 years ago, treatment was specifically restricted to the single type of glaucoma, which we refer to as primary open-angle glaucoma. It is also the most common. Primary open-angle has no identifiable cause and is characterized by damage to the optic nerve from really many factors, but probably the best known is high eye pressure. However, there are many other common types of glaucoma, including low-pressure glaucoma, glaucoma caused by abnormal ocular conditions and ocular inflammation, glaucoma caused by medication use, and glaucoma caused by injury. These other forms of glaucoma are within the training and treatment capability of doctors of optometry using the same methods of treatment that we currently use for primary open-angle glaucoma. For the 13 years that I have been treating glaucoma, although I have had the training, the ability, and the tools to treat these other forms, I have been restricted from doing so. In these cases, I must have my patient receive their treatment from the ophthalmologist. This is unnecessary, inefficient, redundant, not cost-effective, and burdensome to the patient and to the provider. Further, we have rural areas in our state without sufficient supply of ophthalmologists to treat the conditions. A friend of mine, Dr. Angel Sawyer, who practices in North Conway, reports that due to the lack of other providers in the area, or those who would travel to the North Country, her patients are traveling an hour or two for their care when she is ready, willing, and able to treat them herself. Unfortunately, the statute is preventing her from doing so. These restrictions on the treatment of glaucoma by doctors of optometry put in place over 20 years ago are outdated and at this point unnecessary. In the past, New Hampshire was a desirable place for practicing optometry as it was considered to have a pretty good scope of practice. However, with legislative advances in other states, New Hampshire now has one of the most restrictive glaucoma treatment statutes in the country. In addition to these restrictions impacting us as eye care providers and our patients, the restrictions make it challenging to recruit and hire new doctors to our state. Prospective candidates are surprised to learn how they would be restricted here in New Hampshire, and some have chosen to practice elsewhere. These restrictions limit our ability to add top-notch providers to our state. While I have discussed a good deal of what Senate Bill 284 will change, I'd like to reiterate some of what it does not change. There will continue to be requirements for optometrists to consult in advanced cases of glaucoma that are not responding to treatment, acute cases of glaucoma that require prompt laser intervention, or cases of glaucoma in those under the age of 18. It is important to note that we have had detailed discussions with the leadership of New Hampshire's ophthalmologists regarding this bill. And what you have before you is language that includes compromises resulting from those discussions. Senate Bill 284, as submitted, is language that was agreeable to leadership of both optometry and ophthalmology. In summary, Senate Bill 284 will remove unnecessary restrictions on the optometric treatment of glaucoma to the benefit of our patients, our colleagues, and to the New Hampshire healthcare system. Thank you for your time and consideration.
Thank you very much. Are there any questions? Representative Sajak.
This is actually a question for Senator Ward. Was there any opposition in the Senate to this bill?
There is not that we know of. No.
Representative Fellows.
Thank you. On page 1, line 18, there's a reference to therapeutic pharmaceutical agent certified optometrist. Is that a separate certification, or would everybody?
So it is separate. Prior to 1980 something, if you graduated before that, before therapeutic topical agents were added to the statute, which I believe was some point in the 80s, that was its own licensure. I don't actually know that there are really any optometrists in the state practicing. There are none left.
Follow up.
So that would mean we probably could take that out of the statute?
I'm not sure as our license is still written that way, that you're a therapeutic optometrist, a TPA certified. We could look into that.
It may not be as simple as changing
Yeah.
that paragraph, but yes, it's something to consider if we work on amendments. Any other question? Representative Goley?
Thank you, Madam Chair. Why is it taking 20 years to get here?
That is a very good question. I'm not sure. I've been practicing for 13 years. It's certainly been on my radar the whole time. But I think that some of us now, there's no better time than now. So here we are. Yeah.
Yes, thank you. Representative Bailey?
Hi, thank you. Going back to that date, I mean, on line 13, page 1, would the world end if it just said graduated instead of graduated after 2002?
So I think that was the year that this was passed. So I think, the original statute. So I think what they decided was, okay, from this point on, this is what we're doing. And from this point before, this is what we're doing.
But that was 20 years ago.
Yes.
What would happen if now we just scratched out after 2002? Would that cause chaos somehow?
Representative Bailey, we'll take it as another case where this statute could use some fine-tooth combing to
thank you.
straighten it up. But
Thank you.
I think that is the case. Representative Goley, you had no? Anyone else? Yes, Representative Schmidt.
Thank you, Madam
sorry.
Chair. The effective date is 60 days after its passage. It is frequently the case that there's some preparatory action required of the state or agencies or whatever. So they can't put the statute into effect immediately because first you have to have, step one before you have to build a basement before you can build the first floor, right? Is there any reason why we couldn't have an effective date that would be more immediate and relieve our optometrists and our North Country population of the stupidness of this current situation sooner than 60 days?
I'm sure we could work on that. Yes, I'm sure if it was agreeable, we could
Although
speed
I'm
that up.
reluctant to submit any changes that would make it have to go back to the Senate.
That's it. It's the only thing that would make me hesitate. And if that was not the case, then we could, certainly consider speeding it up. But I'm not sure about the ramifications of it.
Okay.
We'll
thank
weigh
you.
that.
Thank you.
Very good. Any other questions? Representative, oh, you got Representative Bailey. Anyone else? Representative Judy, yes, please.
Thank you, Madam Chair. Good morning, Doctor.
Thank you.
How many years someone has to study to become an ophthalmologist and also optometrist?
So for an optometrist, we complete 4 years of undergraduate study, graduating with a degree, often in pre-med. Mine was biology. And then it's 4 years of optometry school. After that, year-round, you graduate, pass the national board exams. You may also choose to become a specialist, which there's residencies available, year or two residencies. Ophthalmologists go to medical school, graduate, decide they want to become an ophthalmologist, and then they specialize in eye care after that, completing a surgical fellowship. This bill is not really highlighting those differences, are touching on educational requirements or training. However, there is, as you appreciate, a lot of overlap between the two professions, and this bill has been discussed by both professions, and there is no opposition. So I think it's a good stepping stone for all of us.
Yes.
Thank you.
All
Other
right.
questions?
Thank you.
All right. Thank you very much.
Thank you.
Is there anyone else who wishes to testify on Senate Bill 284? Senator Reagan.
Before you dismissed your committee for lunch, I had something to, has nothing to do with this.
Nothing to do with this bill. Okay, in that case, I will close the hearing on Senate Bill 284 and recognize Senator Reagan.
I've been involved in this back and forth with the Board of Acupuncture. They
Yes.
can't make up their mind what they want, so this is not ready to be heard today. And they promised me that they will draft, through their attorney, they replace all amendments.
Thank you. Well, actually, Senator, we have a bill that we have an interim study that we were quite far along, that we might just replace all. But thank you. So
Yeah,
you're
I didn't want everybody to come back from lunch and find out.
fine. We will, we appreciate that. Okay. In that case, we are breaking for lunch. Senator Reagan assures us that Senate Bill 282 is not, he's not happy with the current condition, and therefore it may not be ready for us. So if we don't come back on time, we'll start late. All right, happy lunch.
You know how to dance.
I not only know how to dance, I know I can dance. It's not a question of knowledge, it's what's in the leg. You know, I'm kind of gimping along because I
I'm Representative Jackie Grota. I represent the
Hearing first.
sorry.
I appreciate your eagerness.
Sure.
All right, it being 1 o'clock, I'm opening the hearing on Senate Bill 282, and I call Representative Grota to introduce it.
Thank you, Madam Chair. I'm Representative Jackie Grota, representing the towns of Ryan, Newcastle, Rockingham District 24, and I'm here to introduce Senate Bill 282 regarding acupuncture. Thank you.
All right, I will mention that the intent is for this bill to go to Representative Lekas and his subcommittee, and they will review it in the context of House Bill, I think it's 1192, that dealt with the same topic, and fix any issues that may remain. Okay. And Elizabeth Ropp.
Hi, I am Elizabeth Ropp. I'm testifying for amending SB 282, HB 1192. I was in front of this committee a couple months ago, and I submitted about 11 or 12 letters from licensed acupuncturists in New Hampshire, outside of New Hampshire, for making the following changes to the Acupuncture Practice Act. So I just want to point out that the licensing board wants to allow for acupuncturists with a doctorate of Oriental medicine to call themselves doctors, and that's fine. But the changes that we're asking for are allowing equivalent exams, like the California exam, in addition to the exam issued by the National Certification Commission of Acupuncture and Oriental Medicine. Remove the mandate that we have to pay that same organization to maintain active current status in order to keep a license in the state of New Hampshire. It's redundant and burdensome, and it's not used in plenty of other states like Massachusetts, where many acupuncturists come from when they move to New Hampshire to get New Hampshire licenses. Most of my coworkers, actually. And to give the licensing board term limits. So 5 years ago, there were 2 members on the board who finally stepped down after serving for 20 years. It's a lot of gatekeeping. So I'm resubmitting the letters from 1192. There's a letter from my employer. Our clinic has been short-staffed since we reopened from the pandemic. And we've been operating at limited hours, and it's hard to find people to come work with us. And we have to search out of state because there's not a lot of acupuncturists in New Hampshire. And so that active current status with the NCCAOM is a barrier for people to get New Hampshire licenses. There's another letter from my longtime friend and colleague, Diana DeGioia. She's a very senior acupuncturist on Cape Cod, running a very successful clinic. But as she's getting older, she wants to move to New Hampshire so she can be closer to family in northern New England. And she's a great acupuncturist and maintains a license in good standing in Massachusetts, but she doesn't have the current active status with NCCAOM. And so that keeps her from moving to New Hampshire. And another one of my 12 letters is from our accountant. He points out that the NCCAOM is a trade association, and I do have their financials from a website that tracks nonprofits. They're actually listed as a business or industry association, not a certifying body. And I pointed out before that their chief operating officer, Corey Ward Cook, when she stepped down in 2019, her salary was over $250,000. And by law in New Hampshire, we have to pay them and keep active status with them, whether we want to or not, whether we feel like they represent us at the national level or not. And our accountant, Jefferson Chickering, points out that he was the chair of the accountancy board, and the reason why he stopped is because he was term limited out after so many terms. So that's my testimony, and I'm gonna just go ahead and, Representative Lakis.
Thank you. Or a suggestion, that is, I would suggest, I'll end up scheduling a subcommittee work session, and I suggest everybody who's has an interest in this come with suggested language, and we can thrash through it, and hopefully this time get everybody to agree on one thing. So.
Okay, excellent. The deadline for this bill is the 28th, so we'll probably be executing it on the 25th, 4th or 25th.
Thank you.
Thank you. Hope there's no other questions. Okay, Laura Cooley.
Hi, I'm a licensed acupuncturist from Orford, New Hampshire. I'm an advocate for legislative improvements in laws across the country to unwarranted restrictions on practice, which only increase over the 30 years I've been passing laws in the US. So we're just asking a couple very direct things. I believe we have had a hearing on this already. I believe we are somewhat appraised. I just want to say in Chinese medicine, one of the principles we talk about and treat is stagnation. We'd like to get rid of the regulation that enables stagnation in our profession. And this bill puts in reciprocity. If you pass the bill we're asking you to pass, anybody from any other state with a license can practice here automatically. Right now, the way the licensing board has delineated things, 28 states do not meet our standards. Massachusetts is one, California is one, Florida is one. They all have lots more regulation than we do on acupuncture. And in fact, in 5 states, there are 17,000 acupuncturists that New Hampshire Licensing Board deems not safe enough to practice here after they've been practicing in other states. So that doesn't make sense to me. I'm not sure how many states don't have laws anymore. Oklahoma's the only one I know of. But we're really saying that nobody else is practicing in another state can practice here when they apply for a license. This means something to me because it took me a year and a half to get a license here. It cost me $1,700. So I would really like this law fixed. And I believe the amendments we submitted originally, Representative Likas, you have them. I have everything in my grubby little hands.
Yes, this is a different bill. This is the Senate bill rather than the House bill. And like I said, the intent is to take the work we did on the House bill and fold it into this.
Great. So I don't need to say anything else. Is that correct?
Sounds good to me. Is there anyone else are there any other questions from the committee? All right, seeing none. Thank you, Ms. Cooley. Is there anyone else who wishes to testify on Senate Bill 282? Give us a pink card and introduce yourselves.
Okay, can you hear me okay?
Yes.
All right, my name is Molly Gendro of Stratford, New Hampshire. I'm here to share support of SB 282 as a licensed acupuncturist and a board member of the New Hampshire Acupuncture and Asian Medicine Association. Our association represents the interests of acupuncturists across the state, and I'm here on behalf of our membership. We held a meeting in early January to gauge member support for SB 282. And we are unanimous in support of our fellow colleagues that go above and beyond the typical master's degree to get their doctorate. Most acupuncturists in the state hold a master's degree from a 4-year graduate program, and we agree that those that go beyond the typical 4 years to get their doctorate should take on the title of doctor. We are also in support of the changes for the licensing board. This would streamline licensing renewal. And we had a discussion about the supervision of acupuncture detox specialists and shared our recommended changes to the first draft of the bill in January. As it is stated in the amended bill you have before you, we agree that acupuncturists should be supporting acupuncture detox specialists and with supervision. This bill will allow supervision to be more flexible, allowing for in-person or virtual check-ins. I polled our membership and was surprised that out of those who responded, no one had been asked to supervise, and there are a number of people happy to volunteer their time. I do have a list of those volunteers. The New Hampshire Acupuncture and Asian Medicine Association members are in full support of this bill as it is presented to you today and urge you to vote yes to pass SB 282. And I would like to take a moment to mention that our association is a wealth of knowledge for acupuncture, Chinese, and Asian medicine. And we have members that are current students and members that fought for the first licensing of acupuncture here in New Hampshire. So please reach out to us if you have any questions regarding acupuncture or Asian medicine, and I'm happy to answer your questions today. Thank you for your time.
Thank you. Please fill out a pink card and give it to us. And if you can support the subcommittee, we would very much appreciate it.
Yes. Thank you.
Okay. Is there anyone else?
Good afternoon, everybody. I'm Cindy Tirugetti.
Oh, you just turned it off.
Yeah, the reason you can't hear it, you got to kind of eat the microphone, especially for the folks that are watching this from in
Roger
the YouTube
that. Okay,
YouTube world.
how about now?
Better.
All right, I'm Cindy Tirugetti. I am the chair of the New Hampshire Acupuncture Licensing Board. And as you folks know, this bill, Senate Bill 282, mirrors the language in House Bill 1192. Those amendments that you see are from the Board of Acupuncture Licensing in both of those bills, so we're in agreement with the amendments as they are. The only additional thing that we had hoped to do was move away from the word Oriental. That was put into the statute back 20 years ago when it was first enacted. And so that word is a pejorative word now thought by many, and we're trying to move away from it as many of the standard setters in our profession are doing. And so we suggested moving it to the word Asian instead, with the exception of there's a couple of organizations in that statute that are named who have not yet changed their name. So one of them was the NCCAOM. NCCAOM is the certifying body. I'm not sure of their legal corporation status, but they are the standards setter for competency nationally for board certifying acupuncturists throughout the United States. But they are still called the NCCAOM for acupuncture and oriental medicine. So as it's written in the statute, that would have to stay as it is. There is another body, the accrediting body for schools and colleges that teach post-secondary acupuncture programs, and that is the ACAOM. It used to be OM, but they actually have changed their name to the ACAHM, which stands for the Accrediting Commission for Acupuncture and Herbal Medicine. So since they have already changed their name, we thought it would be appropriate to change it in our statute as well. So just that. I was speaking with Senator Reagan about other amendments relating to continuing education. And what he suggested was that we just get a completed statute adoptable as a replace all amendment. And so that will be forthcoming for us. And the reason why we want to change what's written in the statute about continuing education is actually to make it easier for licensees to get their continuing ed units. We had made an amendment, and the way that was interpreted by our board council was that it would look like the only way that they could get their continuing ed units would be if they were through the NCCAOM. And that's not what we wanted. We want people to be able to get their continuing ed units in other ways. So we'll be working on that.
Okay, thank you for that.
Yeah.
It is something that the subcommittee will be looking at. I hope you will support.
Mhm.
And actually, it looks to me, if you look on page 2, line 30, the continuing education, it deletes 2 sentences and adds 1. I think that you just leave the first sentence as is and simply delete the second sentence.
The suggestion that was made by our board council, which I think is a good idea, is pretty close to what you just said. And what we thought we would do is say that they can get their continuing ed units, but leave the number of hours out and actually address that in the rules to expound upon the number of hours that are required in the rules. That doesn't really need to be in the statute. That's what was suggested
The
to us.
other, that's a policy decision, whether it's in statute or in rules, so we'll consider your position.
Okay.
Good. Representative Blackus?
Yeah, so I looked through both 1192 and 282, and the word Oriental isn't in there other than in the initials for that one organization. So are you asking for changes elsewhere in the statutes? as
So-
opposed to just changes in the current bills?
So the word Oriental actually appears 9 times throughout the entire statute, Representative Lakis. So we were looking to change that.
All right, thank you.
Okay, thank you.
Up to you. Representative Judy?
Yes, thank you, Madam Chair. As you are a chair of this organization, how many doctors we have here in New Hampshire, doctors of acupuncture?
I would have to ballpark it, and I think it's a growing number, but it's somewhere under 5 right now. It's a recently established program, the doctorate in acupuncture. So it's something that's new, and we just want to allow for those people who've gone and gotten that degree to be able to use the title. There's not many yet. I would say under 5. We have 153 licensees total.
Okay, all right, thank you. Thank you.
Thank
very
you.
much.
Thank you. Other questions? Yes, Representative Allegro.
Thank you. I'm just curious to know what the degree requirements are. Can you summarize them in a minute?
Sure. Well, for a licensed acupuncturist, you have to have 1,905 hours and a master's degree. So there's different levels of acupuncture providers in the state of New Hampshire. And the top level would be the doctoral degree. I don't know off the top of my head how many hours that is, but it's above and beyond the master's degree, obviously. So it goes doctoral and then master's. And then we have the acupuncture detoxification specialists who are required to have 30 hours of classroom time and 40 hours of practice time under the supervision of a licensed acupuncturist. Thank you.
Okay, Representative Bailey?
Thank you. The analysis on the front of the bill mentions what you mentioned, that you'd like to be able to use the title doctor, but I don't see that anywhere in the bill.
Representative Bailey, unfortunately, the bill in your hand only has page 2.
Oh,
Pages 1 and 3 have more detail.
all right. Sorry
Sorry about that.
Thank you.
I noticed that myself when I was looking for it. The copies that are over there today only have page 2. Those who had copies from previous times have all 3 pages. Not your fault.
Yep,
Any
it's
other
okay.
questions or concerns? All right, seeing none, thank you for your testimony.
Okay, thank you all.
Is there a, yes. Is there, and do fill out a pink card. Is there anyone else who wishes to testify on Senate Bill 282? All right, seeing none, I will close the public hearing. Since that's going to subcommittee. Yeah, take a break. Yes.
Looking for 2 pink cards.
Yes. You've got, yes, I know, they can, one of them is being filled out even as we speak. Yes, they did. We're all set on those guys. Thank you. Yes. I think it got died in the Senate. That's what happened. Everybody forgot, or they came up with new requirements like combing the statute for Oriental or whatever. Yes. Yes, thank you. That'll help.
I'm not sure whether it's in the bill on the elections. We have something here done until way back where the term, I'll get details just in case I'm not here. And that's this. I told you about Dr. Hitchcock taking down on the 25th. First one you have.
Oh, no, you didn't.
I did email you, believe it or not.
I haven't looked at my email lately.
Yeah, I'm just.
I don't
know
doubt
what can
you.
happen, but I did do it. That's
Okay.
all. That's my only point. That Monday, I will. She's getting her. That's it. Plumbing details, but she's got to go to.
Dr. Hitchcock for it. Okay. Get the.
If you want, I'll. But she pointed out.
Anytime, 1 o'clock, maybe. I'll check with, okay. I just want to the extent possible. Yeah. But we need you, so can we get everybody to agree on something? We can't guarantee. Oh, no. Well, then we'll decide. Right. Yeah. To the extent possible, because it looks like some people here wanted to happy with what they have, and some make it minor changes. So, okay, at this point, I was handwriting the thing. I'm not. No, but we can take, no, we can. Actually, if you could send me that,
I might have.
Could you make sure you do again, because I'll need to make it available.
Molly's still here. This is what I say. Dr. Caroline. Molly is still here. And then this is what got turned out. Change, remember that orange?
Now, is this 282 as amended or the original 282 that you marked on? Because I think some of this has been done. I don't know if all. Really? All right.
Language is identical in health and
As amended. Both were amended.
right, but the amendments are. This is.
Well,
This
I,
is what I said.
I'll look at
This
this.
is what Carol said.
Here's the deal. I'll look at, email me if you can, copies, because I'll need to send it out to the subcommittee. Right, and she should have sent me that.
But also, like, I never saw your amended. I never saw that. We never saw that. We didn't know it existed.
Okay, well, it's in, it's been in the system, the Senate had a hearing. The Senate, actually, I can't tell, because the committee, their committee, were going to approve it. It just hasn't gone to the whole Senate. Oh, because the Senate, all right, my understanding was that some of the acupuncturists are going to the Senate, they dealt with it before we did, and they had come up with amendments, and I spoke with, I have to look at my email, I spoke with one of the acupuncturists. And I said, so doing this pattern was supposed to send it to as the Senate amendment. I was told yes. And so what we did then is we came up with an amendment to 1192 to make it the same. But so I thought we were set. So yeah, right. Okay, so the Senate already had accepted 1192 and unanimously put it on consent. The whole Senate has not voted on it. Yeah.
I shouldn't be in stuff.
Well, wait a minute, maybe they did that on the interim study. Still would have. No,
No, they don't get me.
oh, you are.
We did. That's right. That's, hey, so how could they do that?
Oh, wait a minute. Let me see.
For 11, I was there for the hearing.
And we thought, yeah,
Here's the, this is 1192.
Yeah.
1192, we retained it. That's what I thought. We retained it. But Representative March said that you guys passed it and we have it. It's more of this. I thought we retained it. No, we passed it.
No, this is the document for 1190. And then it went, we passed it, that amendment, EDNA, they had a hearing, they reported up.
5-0 consent calendar.
The consent calendar.
And the House has adopted, the Senate holds adopted.
But it will. I think that's all they said.
Right, so what happens if, I mean, they're meeting Thursday, so presumably they'll let it,
They can just still let 1192 become law, in which case we don't even have to do anything. We can just let that.
But it doesn't have the removing the active status testified for to the health.
It's whatever you feel it's loaded.
So one sentence that was different between that amendment on the bill.
In that case.
Which I have an amendment.
What we, if the Senate wants to pass it, it's not going to. What we can do is pass this one, so that it's only effective here. Make sure the effective is that.
Okay, I think it's
override. Oh, I see.
You can override whatever the Senate.
Okay. Yeah. And then you add a little meeting on it to decide that.
So would that be a matter of
I didn't have time to
just changing that part of the bill? And the part's different, and then that part.
Or you could just change the part that you want to overwrite.
So change, replace the whole bill with just the.
Yeah, just make it simple.
Clear to the Senate.
If it's not ready, I'll come back and we'll keep voting you. So we'll have to decide like how.
We passed it, the amendment, which was the language that you guys all set up.
I'm sorry, I put it so. We're not. What is your email?
In March.
Yeah.
Thursday, I mean Friday afternoon, you should be available.
This Friday.
We need to do this.
Yeah, here.
It's the full committee's
That's enough to get me through.
Right, but not all the things, but like Colorado.
Yeah, well, let me just tell you what my calendar looks like. I don't have anything scheduled on Friday, so I can come out.
I'm doing well. Don't trip on this. Can't believe you. Right up. Anyway. You may not recognize
Take a look at it. Explain it.
Well, one of the ways, I mean, because now the funding is already approved. The governor
Oh, yeah.
So, you know, that's what we're talking about. But the thing is, that apparently.
I know it's okay, but it's like a teacher.
Well, the thing is, I just want to let you know that she and I been talking about this. This is an example of where a drug court, this fellow he had a situation, you know, where he was not taking his medication. And he had.
All right, let me get ready for this building.
Oh, yes. So you're the first speaker here, are you?
Sponsor.
That's your composer.
All right, I'm opening the hearing on Senate Bill 330, and I call Senator Gaida.
Thank you, Madam Chair, members of the committee. For the record, Bob Gaida, Senate District 2, and prime sponsor of Senate Bill 330 FN. We've already been before you at least once that I can recall on issues related to OPLC and transitioning that into the position and with appropriate authorities and consultancies that are required to make it function as it was intended. The OPLC has been, if you will, morphing for about the last 7 or 8 years through a number of different executive directors, relocating, which blew their budget out of the water, and a number of other challenges. We have a very competent executive director now in Lindsay Courtney. It was at her request and with my suggestion as well that we put 330 together here. It does a number of things. First, establishes a study committee to make recommendations about how the board, the OPLC, should interact with the various licensure boards and commissions over which it has authority. As you might suspect, when a change in hierarchy or a change in structure takes place, sometimes there are difficulties in establishing lines of communication, lines of authority, and so forth. And so for that reason, this study committee is, I'm quite sure, very necessary. This bill grew out of a omnibus bill, pardon my using foul language, and that was, I think, the longest it was 73 pages long, and that was probably a little bit too long. And of course, with COVID, that was the end of that. But this is a necessary study committee, and I'd ask the committee to move forward with it. Two other things that it does, it deals with bringing the Boxing and Wrestling Commission over onto OPLC, currently attached to Secretary of State, and the revenues for which currently all accrue to the general fund. That according to LBA that I just did research with. And the third thing, of course, it does is it deals with the Board of Foresters, pardon me. It does a little bit to adjust the terms to make it more rational in how people get replaced on those boards. And that is pretty much a summation of what Senate Bill 330 FN accomplishes. I would certainly welcome any questions.
Thank you, Senator. Are there questions? Representative Blackus.
Thank you. You may have just answered my question, but I want to make sure. And that is, after the transition of the wrestling board to OPLC, I couldn't see anything that said where, they have this taxing and fees and everything. So above cost, is that still going to go to the general fund? Does it not need to be explicitly stated?
According to LBA, everything they raise goes into the general fund.
Okay,
through
thank you.
Fees and, of course, whatever inspections they have to perform and so forth.
Right, thanks.
Representative Goley.
Thank you, Madam Chair. Thank you, Senator, for taking my question. Not very familiar with the Boxing and Wrestling Commission, but do they license anyone or regulate anyone? Or, why would we put them in OPLC unless they are actually handing out licenses?
So what they do, amongst other things, they license any event, like an MMA event or stuff like that, and the licensure is required to make sure that the proper medical personnel are there, that the proper protocols for, any of the events that they do is there. And so they're an oversight board, basically, that makes sure that everything's kosher and being safe as possible.
Follow up? I understand the licensing events, but OPLC licenses individuals, and that's why I'm questioning why they are there, because they are not overseeing individuals and prerequisites for actual individuals in licensing. For where I'm going with this.
I do. I'm not sure whether they license, whether boxers and professional wrestlers have to be licensed. I don't know the answer to that. My suggestion would be that may be that the reason that they do this, but again, I don't have an answer for that.
Thank you, Madam Chair. Is it not the case, as I understand it, Senator, that both managers and boxers, wrestlers, and so forth, I don't really know about wrestling. Professional wrestling is a kind of special breed of cat, but I believe boxers also have licenses. When Muhammad Ali was a heavyweight champion, when he had his what? Yeah. I'm saying, is it not the case that his boxing license was revoked? Would it not be the case that our licensed, that our boxers and wrestlers also potentially have to be licensed as well as their managers?
I would surmise that, but I cannot state with authority that that's the case.
Yeah, I agree. I don't know it for a fact.
It wouldn't be hard to find out, though.
Yes, thank you. Representative Pearson and then Lekis.
Senator, am I having a quiche of Vujade here with the sense that I swear I've seen this. Is this part of another Senate bill? I've seen this language in the last month in reference to the moving of the Boxing and Wrestling Commission.
Yes, we had a bill to take them out all from under the
Secretary of State.
Secretary of State's office.
How is this different than that bill?
Well, I don't know. I didn't sponsor that bill.
Because this is okay.
Thank you, Representative Pearson. We'll have to get somebody to look at that difference. Representative Lakis?
Thank you. Yeah, I can answer the question on licensing. 28511, which is under the Boxing Commission, licenses required. No person shall participate in a professional fighting sports competition as a contestant, manager, referee, judge, second, or timekeeper without a license from the commission. The fee for a license issued will be $20, and then there's some other things. So if this is moving to OPLC, we might want to go with the general OPLC of them setting the fees. But otherwise, yeah, there's various people that are licensed.
What's that? RC 310 is their fee. Mm-hmm. Okay. Yes. I will mention that I intend to amend the study committee to also include the funding study that we had that was in Senate Bill 313.
313, yes, ma'am.
Yeah, so I think those of us who would be called upon to serve on both those study committees would rather do it once. Any other questions for the senator? Okay, thank you. And Laura Cooley?
Thank you, Madam Chair, members of the committee.
And thank you to Senator Gaida. He is my senator. And he helped me get my license renewed when the licensing board told me they had no paperwork for me, that I'd lapsed, and I needed to fill out the original paperwork again, which is a stack about this high for me. I support this study commission on reciprocity. Our board is not the only one. I train all kinds of mental health professionals and healthcare professionals. Seems like all of these licenses have real trouble getting reciprocity. I read of a drug counselor in Vermont that had been practicing in Vermont for 2 years and still didn't have their license in New Hampshire. So it's obviously a problem in New Hampshire. I know our motto is live free or die, but when it comes to our licensing boards, it's a misnomer. Thank you very much.
Okay, thank you. Questions? Yes, none. Is there anyone else who wishes to testify on Senate Bill 330? Seeing none, I will close the public hearing.
I have a question of the chair.
Yes.
We've been using reciprocity seems to be a term that's fading away and being replaced with recognition. Do we really mean to say reciprocity, or are we headed toward recognition? Are we going to maintain a distinction between the two?
I don't know.
Oh, okay. Thought I'd ask.
It's a good question.
It's a good question, but I don't have an answer right now. All right. Okay.
Well, if I might, I would just say in response to Representative Seitek's question that I certainly do not think we want to drift into a circumstance in which we equate recognition and reciprocity, since they are related only by the fact that they both begin with R-E.
The thing of it is that reciprocity, well, I'm closing the public hearing on Senate Bill 330, and the reciprocity frequently requires a formal agreement between states. What we want to do is find a way to acknowledge the licenses some people get from other states. I've heard the same thing from mental health professionals having a great deal of trouble getting licenses in this state. And we ought to be looking at why is that the case when they're qualified enough to help it to work in Vermont or Massachusetts. You know, it's not like those states have extremely different qualifications than we do.
No, I'd very much support the effort to try to get a handle on this, that this committee has the competency to do.
Okay.
Thank you.
All right. I was hoping that some of these bills might be easy.
I agree with you. I think there are two that we might look at.
Okay, which ones are those?
I'm thinking House Bill 228 on the physician's assistants and Senate Bill 228 and Senate Bill 284 on glaucoma.
Okay, do you wish to make a motion on either of them?
I would love to.
Okay,
I would move auto pass on Senate Bill 284.
I'll second that.
okay, so that's by Grota and seconded by Marsh. Do you wish to speak to your motion?
Excuse me, I think the testimony that we heard on the Senate bill confirmed that it is a sensible and practical thing to do for the residents of New Hampshire.
Thank you. So
Yeah, the only thing I would add to that is that the current statute creates a situation where there's an incentive both to take care of the patients and on the part of the doctors to actually misdiagnose certain kinds of glaucomas, such as pseudoexfoliative glaucoma, which is very uncommon, just so they can actually take care of the patients. So to align our statutes with current practice makes good sense to me.
Okay, thank you. Does anyone else, Representative Goley and then Fellows?
Thank you, Madam Chair. Very briefly, I'm just amazed that it took 20 years to get this forward to change into statute what should have been changed a long time ago.
Thank you for that. Representative Fellows.
So this is just a technical issue, but on page 2, line 21, I'm wondering if, so that starts with Roman numeral 4, which says, upon certification to treat glaucoma patients. I'm wondering if that title's not applicable anymore. It's really more something like when consultation is required. It's, you know, just, it's like the title's not, but I'm not sure because I don't know. There's A and B.
Right. What
Is
they're
there
really
anything
doing,
under that?
what they're really doing is deleting 4A, which is for 24 months you shall consult, and simply saying that an optometrist shall consult with an ophthalmologist when either of these two things occur, which look to me as though they're complications that you want
Right.
definitely a second opinion.
Right, and if that's the whole part, if that's the whole of Roman numeral 4, then I don't think the title of upon certification to treat glaucoma patients doesn't seem to fit.
It is actually the up on page 1. There's a couple of places they talk about the requirements for getting certified to treat glaucoma, and which is not an automatic part of optometry.
I thought we're making it kind of like an automatic part of, that's what the whole bill does.
Yes, but they didn't do it thoroughly. They kept the requirement for certification. All of page 1 is about that. And so this just says, once you've passed those hurdles by graduating recently or whatever.
Well, that's
what
okay.
you do.
If you think that fits, it just
Well, it looks like
make
to me.
a connection for me.
I think it's fine. Okay. Any other comments or questions, Representative Allegro?
While I was frantically digging through my stack of papers, did anybody bring up the subject of removing that date of whatever it was, 2001, as an amendment? I mean, everybody seemed to you know, it raised eyebrows. So I was wondering if we're going to do anything about it.
If I may, Carol.
Yes,
I
Representative
just,
Pearson.
the gist of what I got from them was that with the other changes that are involved, it just really doesn't matter. So if we can send this through as it sits without touching it, and it works, then we don't have to deal with the Senate having to concur and all of that. I mean, because I asked that exact question. What's up with the 2002 date? But they didn't.
It's not
seem-
just the date. It's down on line 24. It has all that nonsense about how she was describing how difficult it was to find the 25 patients because everybody kept
Mhm.
moving or retiring, or that's also
Right.
in there. Yeah.
That's
But the waiver
yes.
and the striking out on lines 22 and 23 now make that 24-month period disappear.
The thing is that's if we were to start changing that, we would have to change a whole lot of their statute. And if you wish to take that on as a project, more power to you. But
Well, next year, will we then be saying it's been 21 years then?
No.
Like we're now saying it's been 20 years, and why is
no,
it
this
going on for 20
eliminates
years?
most of the restrictions for they already have waivers. I think I'm with Representative Pearson in that you either have to completely rewrite this bill in a large portion of their statute, or you live with some bad some language you don't exactly like. Representative Slackus.
Yeah, I'd say, I mean, it makes sense making that change, but maybe you could take that on as a project for next year.
Yes.
The other thing too that sometimes we get
Thank you.
lost in with this, of course, is when you're changing a portion of a statute, what comes out in front of us is the applicable part. It's not the holistic part, right? So unless you look at the entire section of law, not just the part that's changed, to make a change in this that is referenced in other parts that isn't in front of us has a potentially cascading effect and a contradictory effect. And that's certainly something that we certainly don't want to do because it will make things worse. And where we would have to, if something that seems logical, as simple as removing the 2002 date, if that has to go back downstairs, the lawyers have to go through it. They have to look for conflicts. If the folks that testified seem happy that it's made that date irrelevant, I just think that that's you're opening a can there that's going to send us down a road that isn't necessarily going to help the folks out that were here today.
Thank you.
Okay, Representative Allegro and then Lacus.
Yeah, I'm on board with that too. That none of the proponents of the bill seem to be advocating for that change, and plus what you two have pointed out. So that's fine by me.
Okay, Representative Lacus. Anyone else?
I cover everything. It's just to say again that trying to make those potentially complicated changes at the last minute is probably not a good idea.
Okay, Representative Golding and then Marsh.
Thank you, Madam Chair. And I agree with all that's been said. I spoke to those individuals out in the hallway, and I spoke with Curtis Berry out there, and they are comfortable with what's here because I specifically asked if we needed to amend anything. And with what they've worked on, they are very comfortable with what we have in front of us to do what they want. So I'm happy with that, and I'm going to support this as is.
Thank you. Representative Marsh.
Yes, I would just want to concur that I don't want to upset the apple cart. I also want to point out that as somebody who has been a hospital trustee for years, we noticed that many people like to move to the Lakes region of New Hampshire and retire, including some people who are no longer considered competent to practice their profession in the area from which they come. So there's some advantage to keeping the date in there, even if there's no longer anybody in New Hampshire right now that would cover, because it might cover people who might very well move here.
Interesting concept. Representative Schmidt. Okay, Representative Saitek.
I heard an old saying a while back, and I like it. It's don't let the perfect be the enemy of, don't let the good, oh, damn it.
The perfect be the enemy of the good. Yes, Thank you for keeping us in line. All right. Anyone else have a comment, suggestion? All right. In that case, the motion is ought to pass, made by Representative Grote, seconded by Marsh, and the clerk can call the roll.
Let's see if I can get through this. Representative Rhodes.
Yes.
The clerk votes yes. Representative Pearson.
Yes.
Representative Yakubovic.
Yes.
Representative Lekis.
Yes.
Representative Allegro.
Yes.
Representative Bailey.
Yes.
Representative Santanastaso.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative Judy.
Oui, monsieur.
Representative Schmidt.
Yes.
Representative Marsh.
Yes.
Representative Fellows.
Yes.
Representative Grote.
Yes.
Representative O'Brien.
Yes.
The chair
Yes.
at 17 to 0.
Okay, I think so. All right, the motion passes 17 to 0. Is there any objection to consent? Seeing none, we'll put it on consent. All right.
Madam Chair, I make
Yes.
a motion ought to pass on Senate Bill 228.
Okay. Is there a second?
Second.
Okay. Representative Grote?
Thank you. I think the bill, I'm so sorry, is one that was put together with consensus from all the interested parties. It currently reflects how physician assistants work and puts their rulemaking into statute. So I think that this is a bill that we can certainly pass through this committee to the House.
Thank you, Representative Marsh.
Yes, I think this is true. It's also important that we do our best to support the primary care practitioners in the state of New Hampshire. We know that a great many primary care practitioners have now announced they intend to retire after COVID, and we could easily be facing a shortage, so making it easier for physicians' assistants to take on that role is a very good thing.
Okay. Does anyone else have a comment? Questions? Representative
Madam Chair.
Goldie and then Judy.
Thank you, Madam Chair, and I too will support this. And I think it was a good idea to put in the part that they had the insurance clause in there, because upon, reading through the bill on page 3, line 16, in the event unanticipated availability of a participating physician practicing as sole practitioner due to a serious illness or death, a physician assistant may continue to practice for not more than 30-day period without entering into a new collaborative agreement. So that says they're practicing on their own without the physician, and it is a good thing that we have them insured during that time. Thank you.
Thank you. Representative Judy?
Yes, thank you, Madam Chair. Before I support the bill, or before, I would like to know if the physician make a mistake. What about the assistant physician? So if the parents sued the physician, also they're going to sue the physician assistants?
I think that depends on the case. If they sue the physician's assistant, they will probably also sue the physician, unless it's one of these cases where the doctor was not involved in that particular case. Representative Grote?
I also would like to remind my colleague that New Hampshire is not a punitive damage state, and therefore these cases are carefully reviewed before an attorney takes them on.
Thank you. Anyone else? Representative Saitek?
Now that all the substantive comments have been made, I'm not going to risk an old saying. The reason I've been so dyspeptic about the issue of liability is they can say what they want, but I've never forgotten the case of of a nightclub burning down in Rhode Island, and the radio station that's put on the ads was successfully sued. Now, maybe they weren't protected by statute, but I'm disappointed that people act that way. I'm done.
Okay, people do not always act properly. Any other comments on this bill? Okay, seeing none, the motion is ought to pass on Senate Bill 228, and the clerk could call the roll.
Representative Rhodes.
Yes.
The clerk votes yes. Representative Pearson.
Yes.
Representative Yakubovich.
Yes.
Representative Lekis.
Yes.
Representative Allegro.
Yes.
Representative Bailey.
Yes.
Representative Santo Nastasso.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative Judy.
Oui, monsieur.
Representative Schmidt.
Yes.
Representative Marsh.
Yes.
Representative Fellows.
Yes.
Representative Groda.
Yes.
Representative O'Brien.
Yes.
And the chair.
Yes.
17-0 also.
Okay, the motion passes 17-0. Any objection to consent? Okay, well, while we're on a roll,
Who was these?
Marsh.
Marsh and,
Groda made the motion.
Groda and Marsh.
Seconded on both of them.
okay. terrific.
And the committee report at your earliest convenience. And I have a motion on Senate Bill 313, and I'm moving amendment number 1385, which I sent to you on Friday.
Second.
So, okay, so moved by me, seconded by Representative Rhodes. And I will comment that what this amendment does is essentially take out the study committee on the funding. It's number 1385.
I think it's Amendment 1310. Amendment to Senate Bill 313?
Yes? It's 1385 was sent out to the committee on Friday.
I apologize.
There could be a different one somewhere. But this one just deletes the study committee. And then we will be amending Senate Bill 330, which has a broader study committee to also look at the funding.
1385 is the.
Doesn't it delete section 1?
Sections 1 and 2 and the change to the Board of Registration of Medical Technicians, since we deleted that in a different bill. Yes, Representative Lekis.
Just, so it looks like this replaces the bill. So is this basically the original bill with those three pieces missing and the rest of it's identical?
Yes.
Thank you.
At least that's what I told OLS to do.
All right, thanks.
Representative Rhodes, do you wish to speak to your motion? Or second?
No, thank you, Madam Chair. You summed it up.
Yeah, that's. All right. Any other comments on the amendment? Okay, seeing none. The motion is to adopt Amendment 1385H to Senate Bill 313, and the clerk can call the roll.
Representative Rhodes.
Yes.
The clerk votes yes. Representative Pearson.
Yes.
Representative Yakubovich.
Yes.
Representative Lekis.
Yes.
Representative Allegro.
Yes.
Representative Bailey.
Yes.
Representative Santo Nastasso.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative Judy.
Oui, monsieur.
Representative Schmidt.
Yes.
Representative Marsh.
Yes.
Representative Fellows.
Yes.
Representative Groda.
Yes.
Representative O'Brien.
Yes.
And the chair.
Yes.
On the amendment, 17-0. Adoption.
All
of the
right.
amendment.
In that case, I move ought to pass with amendment on Senate Bill 313
Second.
and seconded by Representative Rhodes. And I will just like to say that this bill continues the process of establishing that the OPLC has the authority to set the fees for the licensing boards. It deletes the contradictory statements in a number of boards, and some of the boards that disagreed strongly with the policy were deleted from the bill in the Senate. So it's there was no opposition to this bill as amended by the Senate. Representative Rhodes?
No, thank you.
Anyone else? Representative Saitek?
In general, I'm uneasy about the direction of OPLC, and when the subcommittee meets that we've established, I would like to participate. In particular, I think we have a wonderful executive director, but this idea of in collaboration with, I think it should, this is more for subcommittee stuff, it should be under DAS, not a direct report to the governor. Things of that nature. I want a better law or a better structure. This is not any, I'm not at all unhappy or casting aspersions on the current executive director. I just want a better feel more comfortable about the whole office, and that's all I'll say now.
Well, the study committee in Senate Bill 330 looks like they are addressing that issue, among others. Okay. Any other comments, questions? Representative Schmidt?
So I agree with Representative Saitek's concerns, and I think that we want to make sure that we're on the record as we are in our executive session here, stating that we want to see the study committee look at this issue, because the structure, I think, is too loosey-goosey and it's defective in several respects. So I hope to be working with the subcommittee on this, or the study committee. Thank you.
Yes, well, it is, I believe several of us will be, because the study committee has 3 members of the House of Representatives, at least one from this committee. And we might add more when we add the scope of looking at the funding.
From your lips to God's ear, Madam Chair.
Okay. Any other comments on Senate Bill 313? Representative Schuett?
Thank you, Madam Chair. I will add further. I think you're probably all aware that Chair McGuire and I have been working on creating an oversight committee for OPLC, somewhat similar to the oversight for Health and Human Services, to try and have an ongoing way to alleviate some of the friction that we've seen between the administration and the boards. So study committee or no, I think an oversight committee is a pretty good indication that the legislature wants to make this work.
Anyone else? Comments? Representative Saitek?
I don't want to be wicked, but isn't that oversight committee the ED&A committee?
It has to encompass the Senate ED&A also. It's a mix of both committees. You don't have to volunteer.
Thank you. Anyone else? Okay, in that case, the motion is ought to pass with amendment on Senate Bill 313. And the clerk can call the roll.
Me too. Representative Rhodes?
Yes.
Clerk votes yes. Representative Pearson?
Yes.
Representative Yakubovich?
Yes.
Representative Lekis?
Yes.
Representative Allegro?
Yes.
Representative Bailey?
Yes.
Representative Santo-Nastasa?
Yes.
Representative Goldie?
Yes.
Representative Schuett?
Yes.
Representative Judy?
Oui, monsieur.
Representative Schmidt,
Yes.
Representative Marsh,
Yes.
Representative Fellows,
Yes.
Representative Grota,
Yes.
Representative O'Brien,
Yes.
and the chair. 17-0 and ought to pass with amendment.
Passes. Any objections to consent? Seeing none, we'll put that on consent and I will write the committee report. All right, thank you. We are now halfway through our Senate early bills. I don't think there's any other bill that might be ready for a vote, and unless somebody else has an idea. All right, in that case, we're done for today. Thank you all. We will be meeting tomorrow and we will have to vote on our final two Senate early bills.
I like it.